Chair will call on Senator Birdsville, who is the prime sponsor of Senate Bill 366. Good morning, Senator.
Good morning. How are you?
I'm just dandy.
Well, for the record, my name is Regina Birdsell, State Senator for District 19, which encompasses the towns of Derry, Hampstead, and Windham. And I want to thank the chair and the committee for hearing Senate Bill 366. This is a pretty bipartisan piece of legislation. It passed the Senate 24-0 on a voice vote. So to start out, since I heard about the Chinese company Fufeng purchasing agricultural land in North Dakota near Grand Forks Air Force Base, I have been concerned about the potential land grab from the CCP, which is why I chose to bring this bill forward. This legislation is similar to a bill introduced in Florida in which the RAG penned an amicus brief in support of their legislation. This bill bans the CCP from purchasing any land near a military base, New Hampshire National Guard facility, or any major infrastructure in the state. In 2021, a Chinese company called Fufeng Group, based in Shandong, China, bought a plot of land in North Dakota as a site for a manufacturing facility, a proposed project that would be based within 20 minutes of Grand Forks Air Force Base, which houses our nation's most sensitive military drone technology and the backbone of our military communications across the globe. While the Air Force has not outwardly opposed this purchase, a major at the base circulated his concerns about the project, which brought broad bipartisan concern, including a statement from the U.S.-China Economic and Security Review stating, "The location of the land close to the base is particularly convenient for monitoring air traffic flows in and out of the base, among other security-related concerns." While the company is not a state-owned enterprise, its chairman previously participated in a provincial People's Congress, a provincial legislature of the People's Republic of China. We must understand that in 2017, the CCP passed legislation, the National Intelligence Law, which allows the Chinese Communist Party to order citizens or a company to assist in any intelligent work. Chinese citizens and organizations are beholden to China. Chinese citizens cannot truly own property. All land is legally owned by the state, which means it's owned ultimately by the CCP. Since at least 2017, federal authorities have investigated Chinese land purchases near critical infrastructure, shut down a high-profile regional consulate believed by U.S. government to be a hotbed of Chinese spies, and stonewall what they saw as clear effort to plant listening devices near sensitive military and government facilities. At the end of 2010, according to USDA Foreign Holdings of U.S. agricultural land, reports China had invested 13,720 acres of U.S. land. All told, at the end of 2020, China had a total of 352,140 acres of land that they had purchased. Currently, Hawaii, Iowa, Minnesota, Mississippi, North Dakota, and Oklahoma already banned foreign ownership of farmland, and legislation has been introduced in Texas to prevent malicious use of infrastructure. It is understood that China can circumvent restrictions on land ownership by buying large U.S. corporations that own agricultural land or purchase interest in overseas corporations that do business in the USA. Additionally, Chinese investors, owners, and workers have emerged in recent years as a new source of funding and labor for illegal marijuana productions. And I do have a letter that I can forward to the committee from Jean Shaheen. Jean Shaheen signed off on it, Chris Pappas signed off on it, to Merrick Garland, asking them to investigate the land purchases in Maine. And I'll read a little bit of that as well. Chinese investor owners and workers have emerged in recent years as a new source of funding and labor for illegal marijuana productions. From interviews with state law enforcement officials, expert on the international drug trade, economists, and lawmakers, the number of farms funded by sources traceable back to Chinese investors or owners has skyrocketed. Chinese owners and workers have become a larger presence at illegal grows in Oklahoma, California, and Oregon. In Oklahoma, close to 3,000 of the state's nearly 7,000 licensed marijuana farms have been flagged for suspicious activity by law enforcement over the last year. The agency believes that 2,000 of those farms have a connection supply, workers, and funding, or both. Law enforcement in Southern Oregon in 2021 reported as many as 20 different nationalities linked to illegal grows. But the increasing amount of Chinese funding and what lawmakers is some expertise as a potential influence of the Chinese Communist Party has caught their attention. Additionally, the Belt and Road Initiative is a massive Chinese-led infrastructure project that aims to stretch around the globe. A 2021 study analyzes over 100 debt financing contracts China signed with foreign governments and found the contracts often contained clauses that restrict restructuring with the group of 22 main creditor nations known as Paris Club. China also retains the right to demand repayment anytime, giving Beijing the ability to use funding as a tool to enforce Chinese hot-button issues such as Taiwan or the treatment of Uyghurs. In January 2022, Nicaragua officials joined the BRA 1 month after severing diplomatic ties with Taiwan. And I know this puts us in a tight spot when we're the live free or die state, but we can and should not make it easy for adversaries to come into our state and work against us. I'm sure you'll hear testimony against this, but any amendments must be very tightly worded because remember, if one Chinese national owns property, the CCP owns the property. And there's a letter dated February 2nd, and I can forward it to you. It's to Merrick Garland, and it's signed by a broad bipartisan group of U.S. senators and U.S. Congress. And in that is Chinese nationals, including those with potential ties to the Chinese Communist Party, are reportedly operating thousands of illicit marijuana farms across the country. A leaked Department of Homeland Security document from August 2023 estimated Asian transnational criminal organizations are linked up to 749 of these sites just in Maine and Washington state alone. Sophisticated Chinese-affiliated marijuana operations have been discovered in California, Washington, Oregon, Massachusetts, Michigan, and Nevada. For example, in Colorado, a Chinese cartel bought suburban homes near Denver and grew thousands of marijuana plants in residential basements. Whether located in retrofitted residential homes or on farmland, state regulatory and law enforcement entities appear unable to address these potential CCP-supported grow operations despite their significant threat to local communities across the country. In addition to growing marijuana, investigators in Oklahoma discovered illicit marijuana growers engaged in human trafficking, sex trafficking, ketamine trafficking, illegal gambling, and international money laundering. So I would, in closing, I would say that we do have a very vested interest, and it's getting a lot closer to home. The states that have legalized marijuana have seen a ballooning of these illegal marijuana facilities growing. With that, I'll take any questions.
Right. Okay, Dick. Representative Thaxton.
Hi.
Hi.
So before I ask my question, I want to establish that I am no supporter of the Red Chinese. However, I am also a real estate broker, and I have to ask this question in good conscience. I understand all of the good reasons for wanting to pass this bill. I understand the threat to our way of life, keeping it really simple. But you're putting a restriction on who I can sell my property to and who can own property if this bill passes. And so that's my concern, because today we don't like the Red Chinese. Fine. What if we don't like Jews tomorrow? What if we decide Catholics shouldn't be able to own property? And that is a real thing that has happened in the history of this country. As you may well know, Catholics couldn't sit in this legislature until the 20th century. So there's all kinds of, I'm concerned that this is a slippery slope, and I would hope that I certainly hope that doesn't happen, but where's the protection that we don't go down that road other than our good judgment?
Well, first of all, Catholics and the Jews are protected under our Constitution. But if you're looking for authority to be able to sell your land to the CCP that is close to a military base, then I would say no, that's where it should stop. China is one of our biggest adversaries, and they have been for a long time. And nothing's going to change on that piece. So I do say that if you're willing to sell your land to a Chinese organization that you know is going to be run by the CCP, and next to one of our military bases or our National Guard, I say no.
Yeah, but let me just clear that question up, because I see this 10 miles, but then I'm looking at this list, and there's nowhere in the state of New Hampshire where there isn't a restaurant, a bank, a dam within 10 miles.
Well,
So aren't you really, for all intents and purposes, banning any purchase of any land by the Chinese government?
We're restricting any purchase of land within 10 miles, as I said, of a National Guard, military installation, and some infrastructure. Nothing is there about restaurants.
Well, I said, okay, it said food and agricultural facilities, including but not limited to farms, restaurants, and food manufacturing. So I'm just going through this list. Now, notwithstanding that I happen to be the only legislator who owns a dam, so that kind of stood out to me. Okay, and I'm saying 10 miles from me. Well, 10 miles, that's town, every town around is within 10. So for all intents and purposes, I mean, bridges. I mean, tell me a town that doesn't have a bridge.
Okay.
It is
I'm
true
okay
we
with
have no
that.
tunnels. It
I'm
is
okay
true
with
we
that.
have no tunnels. I don't believe there's a tunnel in New Hampshire. Okay, right, that is true. Okay, so for all intents and purposes, you are banning any purchase of any land in the state of anywhere in New Hampshire, because there's no place that is going to meet this 10-mile
That
requirement.
is correct.
Okay, great. So
I have a question.
now, Representative Spear.
I can certainly understand the National Guard and the military base. It's not really a military base, it's a satellite listening station up in, I think it's in New Boston.
New Boston.
Is that where it is? Yeah.
Yeah.
I can understand, that kind of thing. And I can even understand preventing the sale of land right near BAE Systems, which is one of the most secure facilities we have in the state. But we also have an agricultural facility. I don't know exactly where it is because I don't know where anything is. That is, the farmers have said, have come in previous bills like that says, please, whatever you do, don't get rid of that. And the Chinese do own that. And it provides a very elaborate, collection of research for the agricultural industry. And it used to be owned by the Swiss, I think, and now it's owned by the Chinese. But the problem, and I feel that we can't really, I don't know what to do with that, but what I guess my question is this.
Thank you.
Are you expecting, if somebody comes to me, are you expecting me as an individual or as a real estate person to investigate these people's background and figure out if they're Chinese, and if they don't, I go to jail?
Well, you have to, because on the transfers, there's a form that you have to sign now for the feds that says it's not you have to say whether it's an out of.
Yeah, but I don't know that anything that they said was real.
No, I know that, but there is a federally mandated form on every real estate transaction that's where you as the seller and affirmatively state that to the best of your knowledge, this is not a external entity.
But the point is, I don't know. The person tells me something, I believe them, I don't know.
Well, yeah,
and-
your defense, he's saying that your defense is that you had that, you signed that form.
Is that good enough
and
defense
yeah,
for
so-
this? Any person who fails
But-
to comply with this section,
Okay.
not that,
All right,
this.
that's a sort of a would you believe. Okay. Other questions? Yes, Representative Herbert.
Does China allow us to buy land in their,
Absolutely not.
Representative Ammon.
Thank you, Senator, for your taking our questions. The bill, I don't believe, addresses existing property that's owned or potentially owned by an entity that, there could be a long string of shell companies that goes back to the CCP. Do you intend to sever ownership of land that could be potentially traced back to the CCP, currently owned?
Well, this bill wouldn't take effect until after that transaction, so I would say no.
Okay.
But I think at the time, if they decide to sell it, then the new seller could not be a member of the CCP.
I see. Thank you.
And this is only for sales, not for renting?
As far as I know.
Okay, so I could-
Again, this was a piece of legislation that our Attorney General had, he did an amicus brief on the piece of legislation down in Florida, so they strongly support this.
got it. Okay. Representative Burrows, yes. I'm sorry. I keep wanting to call you Anita, sorry.
That's okay. Thanks for taking my question. I think one question that some people may have is, what can we do to protect Chinese who may be here from other countries, even U.S. citizens, from discrimination in when they want to buy this type of property? How can we protect them and the realtors who may be selling to them, and how do we do that?
Well, the one thing that if they're U.S. citizens, regardless of what their nationality is, they're U.S. citizens, they are eligible to purchase. But understand that if they are Chinese nationalists or a Chinese company, in 2017, the Chinese passed legislation that would require anyone who's a Chinese national, they don't own the property, the CCP does. So we need to be very cognizant of the fact that if you're selling to a Chinese nationalist, you are virtually selling to the CCP. Because under Chinese law, the individual does not own property, nor does the Chinese company. They are required to work under the CCP guidelines.
Further question, may inquire.
Thanks. What I was actually getting at is, let's just hypothetically, a Chinese person comes over from London. How do we protect them? And maybe, how do we protect them against discrimination for having them associated with the CCP when they're not?
Now, I know there are certain individuals that come over, like, let's say their children are going to school at Phillips Academy and they either purchase or they rent property. That should not be an issue. But if you're going to be purchasing land around any of those facilities, then it's going to be a problem. Just like Maine's having the problem with Maine and California, 729 parcels of land the CCP has purchased, and they're growing illegal marijuana.
But that doesn't, I guess, I still don't hear an answer to the question, which is a citizen of Britain comes over here and wants to buy agricultural land, say near New Boston, you know, how, number one, how does the realtor know that they're not, you know, how do they investigate to find out that they're not affiliated with the CCP or that their rights are protected to be able to have them buy land?
Well, if they're a citizen of England, then they're not a member of the CCP.
Okay, that's what I
Okay.
So, can you just read what you said before, that if somebody, a student is at Phillips Andover and they're from the People's Republic, you said it wouldn't be a problem for them to buy a house?
I would think so.
Well, it's got to be 10 miles of a restaurant. So they can't.
Okay?
And has also been pointed out is that lease is in here. So that means as someone like me who does vacation rentals, I've got to figure out whether the person who's renting the property is from China.
Yes.
You just lost my vote. Okay.
Did I ever have it, Representative?
Probably not.
That's what I thought.
But you just helped me kill it in my own mind. Okay. Yes, Representative McHugh.
Thank you, Mr. Chairman. Thank you, Senator, for bringing the bill, and thanks for taking my question. My question is, the United States has a number of serious enemies of the state, like Russia. Should we also restrict transfer of real property to those enemies of the state, like Russia?
I would say not yet. I mean, there are pieces of legislation out there that have restricted Iran, Russia, China, and I think there was no. There's one other one. They have restricted. We are just looking at the CCP because the CCP is really the largest perpetrator in our country on purchasing land, purchasing businesses.
Follow up.
Further question may inquire.
When I read through some of the details of the bill, I had not noticed that it's quite broad and is a full restriction because it does include like bridges and restaurants. Would you be open to amending it so it's a little more narrow and restricts transfer of real property to areas around our most critical installations, like the actual military bases and not just every bridge and McDonald's?
I would, and I would also be willing to look at, if you wanted to amend it to protect individuals who want to lease or purchase for the purposes of residential. But I would be very careful when you do that because, I'm sorry, ask the question again.
So
I diverted and I forgot.
it's pretty broad, and while I think that the principle of protecting our country's most valuable and our state's most valuable assets, especially our military and our special secrets and things that so many people don't even know about in New Boston and whatnot. And our critical infrastructure is important, Seabrook Nuclear, those things. But restricting the open commerce that's so important to our state, like renting an Airbnb a mile from a McDonald's, which is really what this would restrict, that might be a little broad. I'd be happy to work on narrowing the scope of this legislation if you'd be open to it.
I am.
Okay.
I would be very cognizant too of the fact that we're talking about the agricultural business as well, and the Chinese have infiltrated that with their purchasing land for seed propagation, and they're gaining more and more of our food lines. So I'd be very cognizant of that as well.
Thank you.
Okay, Briselli.
Good morning. Thank you
Morning.
for taking my question. Do you know if other states have enacted this legislation and how they're dealing with researching, as Representative Ammon said, there could be several different shell companies until you get to the real owner. So that just seems to be a complication of how to do that research and what is the experience of other states if they've passed something similar. Thank you.
Other states have, as I stated in here, Hawaii, Iowa, Minnesota, Mississippi, North Dakota, and Oklahoma. They've already banned it. So what I can do is try and contact some of the representatives in that state and see exactly how they protect residents.
Ammons next, and then Representative Spear.
Yeah, thank you again for taking our questions. And just to follow up on the previous question, has there been any analysis of currently owned property in the state? Is there a way to figure out how big of a problem this might be currently, based on, you know, titles and deeds of existing property?
You mean in New Hampshire?
In New Hampshire, is there, if there isn't, you know, is there a way to figure out how big of an issue that this is currently?
I can talk to Attorney General, Assistant Attorney General Chris Bond, who helped me write the legislation, and see what he can find out.
It'd be good just to get a handle on how big of a problem it is currently. Thank you.
Representative Spear.
This may be a would you believe. I retired from BAE Systems in 2020. Prior to 2020, and at the time of my leaving, we had personnel there that were Chinese nationals holding green cards. And BAE Systems has some of the highest secrets in the country. They had no problem. They did their security investigations and did whatever they do, and they had no problem hiring these people, and these people bought homes here in New Hampshire. So I'm not clear on what we're expecting here, especially in light of
Okay.
even BAE Systems didn't have a problem.
Would you believe?
Would you believe?
I would believe that because I also worked at Raytheon. Over the past few years, though, it's been becoming a problem in the security aspect of it. Now, BAE may very well be doing their due diligence in the background check, but as we said, I will look through the other states that have passed it, try and talk to some of their representatives and find out how they protect if anyone's coming in to purchase land or purchase a house so that they can see their kids graduate. I will look into that and see how they protect them.
Or rent it, a vacation rental.
Okay, vacation rentals.
Okay.
I wouldn't want my son-in-law owns one, so I wouldn't want to stop him from making money either.
Representative Rapner.
Thank you. Thanks for taking my question. I guess I'm concerned about enforcement because the bill does not actually require a seller or anybody who's renting property to do any due diligence about the buyer or the renter. And there's no reference in there to any government agency doing research into these purchases. So how would it be enforced?
And that's a question I'll ask Chris Bonds. Because, I mean, obviously he had it when they did the amicus brief in Florida, they obviously had a process that he was thinking of when they put that amicus brief together.
Okay. Thank you very much for your testimony.
You're welcome.
I have one card here, Robert Johnson from the Farm Bureau, who is in opposition to the bill. Good morning.
Good morning. Thank you, Mr. Chair and members of the committee. For the record, my name is Rob Johnson, and I appear before you representing the New Hampshire Farm Bureau as the Federation's policy director. And we do oppose the bill as drafted. We certainly share the concerns and support the intent of the sponsor, no doubt. But as you've pointed out, the bill as written is very absolute and it's broad. There's no ability for somebody to plead their case as to why they don't fall under this category. And as has been pointed out in the bill language itself, it does include in lines 8 and 9, leasing, possessing, or exercising control in addition to ownership. And it is, as has been pointed out, it's this critical infrastructure as defined is very broad. You look on page 2, line 18, where it says the word farms. Well, my forest land is part of my farm. I know many people think it's just your cropland, but my forest land is part of my farm. New Hampshire is 84% forested. Yeah, there is federal lands that are forested, but still, and state lands as well, but still, again, it's just very, very broad. We would, as the committee did with the previous bill that I testified before you earlier this year, House Bill 1183, you're holding it for study. We'd encourage you to do the same with this. Take a look at the law that recently passed in North Dakota where the military installation and this became a public concern. There's some language in that statute that enables the leasing of land for agricultural research purposes, which is something I mentioned to you before, that we would not want our state university to have to pass up an opportunity to bring in some dollars, research dollars to study a local agricultural concern. And another area you should be aware of is that there are Chinese entities that lease storage facilities in the state for, we're thinking the purpose of high value logs, where they will purchase these high value logs, store them until they can ship them back home overseas. That's very lucrative for landowners. These logs, it's something that, again, that you should be aware of and look into how that may be accommodated. And I guess just in closing, I also mentioned that the first state to pass a statute similar to this was in Arkansas. And this past fall, there's a seed company in Arkansas that it started in Minnesota and back around the 1895, something like that. And eventually it's now a wholly owned subsidiary of Syngenta, which is Syngenta is basically a Swiss company that is headquartered in Switzerland, that was purchased by ChemChina in 2016, something like that. Anyway, because of that line for the seed company, they have 2 years to sell the 160 acres of research land that they own. That company my understanding is they are all American workers. Most of them live in the local community. They were if not the largest, one of the largest contributors to the FFA in the state of Arkansas. And it's just not, it's not clear, cut and dried as to, the Chinese control in some situations. And that's why we believe that, though we do support the intent that you do need to look into some of these other areas that it just doesn't make sense for us as a country, to be restricting this that broadly. And again, we do support the intent. I'll leave it at that. Thank you for your time and attention.
Thank you very much. Okay, I think we're all set. Having no more cards, I will close the public hearing on 366 and go right into our next bill. Okay. All right. Yeah. Karen, did you fill out a card? Okay, great. Thank you. I'm good at piles.
Sometimes I'm just not.
That's right. Well, okay, we will open up the public hearing on Senate Bill 423 and hear from the prime sponsor, Senator Carson. Good morning, Senator Carson.
Good morning, Mr. Chairman, and good morning, members of the House Commerce Committee. For the record, my name is Sharon Carson, and I have the pleasure of representing Senate District 14, comprising the towns of Auburn, Londonderry, and Hudson. And this morning, for your consideration, I have Senate Bill 423, relative to mandatory disclosure of insurance policy limits. As you can probably tell, there are a lot of people in the insurance company that are behind us, so I think you're going to have an interesting day already.
Every day is exciting for this.
Well,
Senate
I
bill,
looked
for
at your
sure.
docket, and you've got everything from the land issue, now this, IVF. You're just getting a little bit of everything. So I imagine that keeps things interesting, Mr. Chairman. Mr. Chairman, this bill is about the disclosure of insurance limits. It has significantly it has changed from the Senate when we had the Senate hearing. I listened very carefully to the issues concerning the insurance companies. It originally would have applied to all businesses and every kind of a situation. But again, we heard a lot of complaints about that. So it changed in two ways. Number one, it is significantly narrowed to only deal with motor vehicle accidents. And there was some concerns that were voiced about protecting an insurer's policy and their privacy. And language was put in there that does that. But what does this bill really do? And I don't know if people are aware of the fact that if you get into an automobile accident, that in order to get information about the other person's policy, you actually have to get an attorney and sue. That seems to be pretty outrageous. Why should you have to do that? And what this bill does is it makes it easier for an individual to get that information and request it. There's a saying, Mr. Chairman, that information is power. And there's a concern on the behalf of the insurance industry that if you, as someone who's been injured, find out about the other person's policy limits, that you're going to go for the whole thing. Nothing can be further from the truth. I think those of you that have been on Commerce for a while know that there's a number of factors that are in play when someone does make an insurance claim against somebody. And I will talk about those in a few minutes. But when it comes to a failure to divulge the policy limits, what could happen is you could have a judgment that's in excess of that policy limit. That's one of the chances that an individual takes or a company takes when they do not give you that information. As the argument goes, revealing liability limits could have avoided this liability beyond the applicable limits of the available insurance. In many states, an insurer's failure to reveal policy limits at the pre-litigation stage can serve as a basis for a third-party bad faith claim. Furthermore, because of a failure to disclose policy limits could be instrumental in resolving a conflict of interest favoring the insurance company's economic interests over those of its policyholders. An insurer, a liability carrier that refuses to reveal their limits, again, could be exposing themselves to a bad faith claim. Whether or not to reveal an insurer's liability policy limits is a sensitive issue because it lays bare a point within the claims process where the interest of the insurer, which favors the insurer not to reveal policy limits, diverge those of the insured, and this is a revelation which aids the settlement and may prevent actual litigation. A demand for policy limits is routinely alleged to be necessary in order to properly evaluate and settle a case. That, I think, is extremely important. Most people will settle. They'll work with the other's insurance company. They might hire an attorney, but they're going to aim for settlement. You will see people that will sue for large amounts of money, and it depends upon the type of damage that's happened to you as an individual. You might have sustained serious physical injury, very expensive medical claims, ongoing treatment. All of those things are considered. But if you have to hire an attorney to even begin the process, I just, personally, I don't think that that's appropriate. I think you should be able to get that information. If a settlement demand is within policy limits, the demand is rejected and the insured experiences a judgment in excess of policy limits for which the insurance company refused to indemnify, and quite frankly, a bad faith claim is going to follow. This bill is necessary because of all 50 states, New Hampshire is only one of 4 that does not have a bad faith cause of action that might be triggered by an insurance company not disclosing policy limits to a plaintiff. New Hampshire is the only New England state that does not require pre-suit disclosure of policy limits. The language that was amended in this bill comes from one of our neighboring states, and we know that in New Hampshire, the vast majority of civil cases will settle pre-trial. This saves time and money for all parties involved without having to go through costly litigation. There may be a concern that if an injured person knows the policy limits, that will become the amount to be claimed in the case. I've already mentioned that. But that is, quite frankly, unfounded. A person's damages in a case are determined by many factors, such as medical bills, lost wages, pain, and suffering. The assessment of damages will need to be supported by evidence. You have to have evidence. You have to have proof of the injuries. You have to have proof of the medical bills. The assessment of damages will need to be, again, supported by evidence. Simply knowing what the policy limits are in a case does not change those calculations. This bill simply ensures that a person injured by a person with insurance coverage available to them knows how much insurance coverage is available to cover the claim. Senate Bill 423 does not impact the cost of damages. It merely informs the injured person whether the person who caused their injury has enough insurance. This bill makes disclosure mandatory without having to file a lawsuit and will encourage judicial economy. Mr. Chairman, at this point, I think I'm going to conclude my testimony, and I will be happy to try to answer any questions. Thank you.
Any questions? Representative McGee.
Thank you, Mr. Chairman. The last time I remember dealing with this was when, thank you, Senator, for taking my question and for bringing the bill back. I think the last time we dealt with it was when your husband was my vice chair on this committee, so 20-some years ago. And we had a learned colleague, Representative DeFruscia, who was super knowledgeable on this issue. And we studied it, and for whatever reason, it didn't go forward. But 20 years has passed, and since then, about 19 states have enacted it. So in the 31 states that haven't, what I'm wondering is, is the practice for the insurance companies, will they just tell you if it's a low limit because it'll make you go away and they'll settle for nuisance money? So the implication being that if it's a high limit, they may not want to disclose it. And so you can infer the opposite is true. And right, so if there are deep pockets, they may be less likely to disclose. And if it's 510 or 1020, does that make sense?
I thank you for the question. I think I understand it. I think it's important to realize what really happens is you have to hire an attorney first in order to get what the policy limit is. So this says you don't have to hire the attorney. If you make the request, they have to tell you. That's what this bill does. If you find out early, without having to file a case in court in order to get them to divulge, you could work towards a settlement earlier, not involve attorneys. You figure it out. If you want to hire an attorney, fine. But I find it egregious that you have to hire an attorney in order to find out what the limit is. And there's a formula as to how what you've gone through, your pain, your suffering. You've got bills. You just can't pull a number out of the air. You're going to find out what the policy limit is anyway at the end of the day. But why should you, the injured party, have to hire an attorney in order to find out what that policy limit is?
Why do you have to file an attorney?
That's the issue. You're going to find out. But in order to find out, you have to hire an attorney. You have to sue to get that. Why should you get that? Why should you have to go through that?
I think the
Why do you have to
issue
hire an
he was
attorney?
pointing out was that if you request and they tell without having to go through the lawsuit, and they tell you, well, the limits are only 50,000. They have a minimum policy, 50, 25. But that if they don't tell you, that should tell you something right there. That if they don't tell you, that means they're probably like me and have an umbrella. And frankly, I'm not sure I really want you to know that I have an umbrella, but you'll figure it out real quick when you see the lawyer that I show up with is my insurance company's lawyer.
Mr. Chairman, I understand that, but I don't think that the average person should have to hire an attorney.
Got it.
That is, I think that's just egregious. You're going to find out in the end anyway.
The only problem I have with your point is the whole reason this bill is in front of you is because there has to be a lawsuit. At the end of the day, there is absolutely I don't want to identify what kind of lawyer, but it's a lawyer you've hired to help you win this case to get compensation. You have already hired a lawyer. You already have that lawyer. Now, if that lawyer says, well, I'm going to charge you $250 to file this claim, that's just part of the legal bill that lawyer is probably going to say is, I'll get half of it once we get our settlement. So your whole issue is saying you have to hire a lawyer. I'm just saying is I doubt there's anybody that is ever in this situation that wasn't going to hire a lawyer at all and now only has to hire a lawyer just to find out the ends, that the reality is, in any of these cases, you always have to hire a lawyer.
Well, thank you for that, but I think it's kind of hard to come to that conclusion, Mr. Chairman, because you have to hire a lawyer to begin with. You have to hire the lawyer to find out what about the insurance policy.
You have to hire a lawyer no matter what.
Yeah. And so if it is that low number, you give people the opportunity to settle.
Right. No, I'm
And
saying
most
if
of
it
these
is a
cases
low
do
number, they'll
settle.
tell you. They'll be more than willing to generously tell you that number. It's only when it's not a high, when it's a
Mr.
high number, that's when they're being a little coy and not so excited about telling you and about it.
Mr.
Would
Chairman,
you
the
believe?
testimony
Would you
that we
believe?
had is they don't divulge anything. They do not voluntarily give you a limit. That is the testimony we had in the
Okay.
Senate.
So I just had someone call me and told me differently. Said
Okay.
that often they are told.
Are they on the
and-
record, Mr. Chairman?
I don't see their card. That is true. They haven't filed a card in here, but they called me and told me in no uncertain terms that if the number's low enough, that absolutely the appraiser probably tells them. The adjuster will tell them what the limits are. Okay, Representative Ammon has a question.
Sure.
Thank you, Mr. Chair. Thank you, Senator, for taking a question. And you actually touched on the gist of my question. If someone has a homeowner's policy or an umbrella policy, is that included? Are they included in this definition of insurer for this bill?
This only deals with automobile insurance. So it would it's just automobile insurance. When the bill was originally filed, it would have included everything. But we heard from businesses that they were very, very concerned about this. And so we said, okay, what is the most contact that you would ever have? And it usually is some sort of automobile accident. Your car's been, I don't want to say injured, but you've sustained some sort of damage to your vehicle, or you have been injured in some way. That's what most people experience. So we just focused on
Further question?
automobile insurance. And we also heard from the insurers, and the changes that we made are reflected in this bill. And it's unfortunate that they're just not interested in any kind of a compromise. And you can tell when they come forward to testify. And that's very disappointing. It truly is.
I just have a follow-up question.
Yes.
How is the insurance company of the other party, how is it disclosed? I guess it could be in a police report, but is it mandatory for the other party that you're potentially trying to get damages from to tell you who their insurance company is? And in what circumstances does that happen?
There's no law saying that they have to tell you. We do not have mandatory car insurance in the state of New Hampshire. We don't have an insurance card that we have to carry somewhere in the vehicle. So if you get into some sort of automobile accident, you present your card to show that you have proof of insurance. Right there is the information. But we don't do that here in New Hampshire. So if the other party voluntarily gives you that information, that's great. You've got a place to start. But there's no requirement that they disclose information to you at all.
Except if you drive out of state, then you better have one.
Right. Well, that's, Mr. Chairman, we can only make laws for the state of New Hampshire. We can't make every surrounding state as great as we are.
Right. Representative
Thanks for
Burrows.
taking my question, and this is relative to the chairman's point about that you're going to have to hire a lawyer anyway. Isn't it true that there are a significant number of people who they're not going to hire a lawyer because a lawyer is going to ask for a retainer up front, and they're going to say it's $250 an hour minimum, and there's no guarantee that you're going to win the case and that they're going to, unless they take it on a contingency. So there are a lot of people can't come up with that. Is that not true?
Yes, that is true.
Thank you.
Representative McHugh again.
To the point I think someone just mentioned, what happens, and actually happened to me, what happens if both parties are from New Hampshire, and in the case for me, the accident happened on Pawtucket Boulevard late one night in Lowell, Massachusetts. Both insureds, myself and the other guy that hit me head on, were from New Hampshire. And as the case may be, when I asked the question, by the way, the first visitor to the hospital the next morning was one of those lawyers you mentioned that I didn't hire, and true story, I didn't hire. What happens then? And I asked the question, because he asked the question, find out what your policy limits are and call me back. And I asked the question, and they told me, and then days later, they reluctantly said, well, there's something that we haven't told you, and that's you're both insured by MetLife, which was, so there's no subrogation. We're negotiating against ourselves. And they did eventually disclose the policy limit, which was crazily the same for both parties. So what happens then? Happened in Massachusetts. Both policies were New Hampshire residents. He was from Nashua, I was from Merrimack.
Thank you for the question. I am not an expert in insurance, and I am not an expert in the laws of Massachusetts. We know that each state does things differently. So I really can't answer that question. But there are folks here that I think if you were to pose that question, that could probably answer that question. And I don't want to give the committee misleading or bad information.
It was an oddball, and
Yeah, thank you very much. Okay, we'll call on thank you very
Oh,
much.
thank you, Mr. Chairman.
Call on the insurance department. Senator Carson, do you have written testimony that you can put in,
I just
submit?
had some notes scribbled down.
Okay, no problem.
Thank you.
We've got it all on YouTube. Yeah.
Good morning. My name is James Fox. I'm the Property and Casualty Director at the New Hampshire Insurance Department, and I'm joined here by Emily Doherty, who's the Property Casualty Attorney at the department. The department opposes the bill on two grounds. First grounds, we feel it's unnecessary based on the current state of law, and we also feel it is a financial privacy invasion of policyholders. I mean, the law talks about claimants and it talks about insurance companies, but the other entity involved is the policyholder. As to why it's unnecessary, there's really two phases. There's like a front end phase and then a back end phase. On the front end, auto insurance, as those of you who've been here a while know, is unique in New Hampshire. It's not like figuratively unique or kind of unique. It is unique. We have a unique system here, and our system is designed so that when you buy an auto insurance policy, you are able to protect yourself. So you choose your limits for liability. So if you go out and you hit someone in Lowell, Massachusetts, those would be your liability limits for the person you hit. But what you get with that in New Hampshire, since we don't have mandatory insurance, is that you get an equal amount of uninsured motorist coverage. So if you're concerned about that you might get into an accident and you might be injured, your first line of defense is to have a high liability limit, which would then give you a high uninsured motorist coverage. So if the person you hit, if they have a 2550 small policy, but you have, say, a single limit 500,000, then you're going to have 500,000 for your injuries. And then layered on top of that, you then could get, as Chairman Hunt said, an umbrella policy. But that's the first line. So that's really how our whole state system has been designed over the years, is that since we don't have mandatory auto insurance, the design is that you are able to protect yourself. But I understand that not everybody can afford a high 500, a high policy with an umbrella. So then we have another layer of protection that we have at the department, and that's called 417-415. It's called unfair claims practices. So that is how we handle the issue of how the insurance company interacts with the claimants. And the first line is they have to, before they settle, we require them to do a reasonable investigation. And so just keep that on a simple level. I think someone mentioned a police report before. If an insurance company tried to settle early and settle low, if there's a significant injury, and to say they didn't get a police report, and then eventually we do what's called an examination, and then every time they've done that, they get fined on that every time, $2,500, $2,500, $2,500, and then they have to get an action plan to make sure they don't do that again. And then the next line, and the next section, that's 3. Section 4 is they have to equitably settle. They have to settle fairly. So if they're not settling fairly with you, again, that's another violation of the Unfair Insurance Claims Practices Act. And it is true that generally how, from the department's perspective, how this generally does work is if you have a low limits, well, it could be one of two things. You either have a low limits policy and they're just going to tell you it's a 2550, they're willing to settle with you if you're willing to, sign a settlement, a release. Or you could have a serious situation like somebody died, and then even if it's a higher policy, they may say, look, this is what we have. We're willing to settle for that amount. But again, if it is a high amount, then they tend not to do that. And the department understands that. So as I said earlier, in auto insurance, you're able to protect yourself. And then I always say you should protect yourself and, have the highest limits you can have, because that, if you actually get seriously hurt, if you end up in a wheelchair, you're going to want to have high limits. But if this bill were to pass, there is a concern that now saying that you would, the people, the proponents of this bill may be great people and not doing that, but there might be some other attorneys out there who may use it as a leverage to say, we're going to work this more to get the number up, and that's a concern. So then we'd have to change our, get as much insurance as you can to protect yourself. To, there is a possibility you will have to disclose your limits, so you may have to consider that also. And then and before I forget, so I'm talking about 417.4. So there's also one other provision that says they're not supposed to offer you a settlement substantially lower than the value of what your claim is. That was added not too long ago. But the other issue is, I think someone mentioned this is currently in the new version, which is you must disclose limits, is currently seated in the Department of Safety's law. That would not be, if you wanted to go down that road, that would not be the right location for it. It would be 417.4. Because what you've basically done is put something in the Department of Safety's law that is an insurance conduct issue, which they don't really handle. They do financial responsibility, which is how much you have, but they don't do conduct. And you also gave the Department of Safety the ability to fine the insurance companies for that conduct issue. So that's always been with the insurance department. And also I would add, and there was something that somebody said that you needed to have an attorney to get your limits. That is not true. That's not in the law anywhere. So basically, if you ask, and it's a low, whether you have the limits are low, you should get the answer. As I always said, we're going through all of these issues, and there are laws. We have a group of people at the insurance department called the Consumer Division. And so if anybody here has a problem with an insurance company, they don't feel like they're being handled, the claims being handled correctly, you can call the insurance department, and we will help you work through the claim. And if we feel that the insurance company has violated the Unfair Claims Practices Act, again, on an individual basis, on a one-claim consumer claim, so not when we're doing exams, we'll also fine them in that context. So all of this is designed to make sure that the insurance company does what they're supposed to do. We don't feel that there's going to be any added protection if you have a disclosure limits. What you're going to have, if you say is a mandatory disclosure limits, is you're going to run afoul of INS 3000. INS 3000 is one of our rules, and it's one of the rule basically protects the financial information of policyholders. So obviously, insurance companies are, to a certain extent, in a lot of states, they're regulated by the same entity, like banks. And so, just like banks and insurance companies, we do not want them giving out the private financial information of residents of the state of New Hampshire. So in that, they usually, how it works is they explain how they're going to use your information. But if you want to opt out, you're allowed to opt out and say, don't give my information out to anybody. And so they really, currently, if you ask them to do that, they should not be giving out your limits because you've asked them not to. And then the last thing, somebody mentioned that this is from another state. I believe it's Maine. And again, we said how unique New Hampshire is in auto world. Maine is not like that. Maine is a completely different regulatory structure. So if you wanted to do that, you probably would need to bring the whole Maine regulatory structure over. You shouldn't do it like piecemeal because we have a system in New Hampshire. The department feels it works very well and it protects the residents of the state of New Hampshire. And we would like it to remain as is. And I'm happy to take any questions.
Great. Representative Burrows.
Thanks for taking my question. I just want to make sure I understood you correctly. Are you saying that if somebody wants to know the limit, they can get it as long as the other party hasn't opted out of financial disclosure? Or did I misunderstand that?
What I was saying is somebody said earlier you have to have an attorney. You don't have to have an attorney. That's not a standard to get the limits. As it's been expressed here, it's accurate. If the party has a very low limit and you have a serious claim, the insurance company wants to end it too. And if you're willing to take the low limit and not go any further, and maybe you have your own uninsured motorist, they're going to tell you that the limit of the tortfeasor in this case is only $25.50. We'll just give you the limits, and then you go to your insurance company and you have a much higher policy. Then you say, they offer me the $25.50. I'd like to take that, and I'd like to make an uninsured motorist claim. And then they say, okay. Then you go down the road on your uninsured motorist claim, and that's why, if you're able, you should have a high limit on your uninsured motorist claim, uninsured motorist limits on your policy. So just all I'm saying is that the way the world works is that if somebody has a low limit and the insurance company thinks they can get out, they will tell you those limits. If somebody has a very high limit, then there are a lot of other variables that come into play, and the insurance company is not as willing to tell you the limits because they are afraid, right or wrong, of becoming a target.
Any other questions? Thank you very much.
Thank you.
Okay, Israel Piedra.
Chair, for the record, Israel Piedra. Turn your mic on.
Yep, sorry.
For the record, Israel Piedra. I'm an attorney in Nashua at Welts, White & Fontaine, a law firm. I live in Manchester. I was a member of the House for 2 terms. I'm here to testify in favor of this bill. The first thing I'll say is that it really is a small bill in my mind. It's not world-changing. It's a technical fix. It makes a small but meaningful common sense change, and it will improve access to justice for folks in New Hampshire in, again, a small but meaningful way. So that's the first thing I want to frame. We're not changing the world here, but I do think it's a step in the right direction, and I'll explain why. So why do we need this? So the typical example is someone comes into my office, they're a client, they were injured in a car accident. As an attorney, we make an evaluation about what that claim might be worth. And so I might advise the client, I don't think that you should settle for less than $60,000. You were out of work for a month. You incurred tens of thousands of dollars in medical bills. I think that your claim is worth $60,000. So we present that information to the other driver who was at fault, their insurance company, and they make an offer of $50,000. Now, under current New Hampshire law, which we're trying to change, the insurance adjuster may know that the insured's policy limits is $50,000, and that's the maximum they can offer. But they don't have to tell me that And in fact, as you just heard from the insurance department, apparently under current law, they're not allowed to tell you that. And so there is, in fact, in practice, some differences of how that works in practice. Some insurance adjusters will give you that information voluntarily, but under current law, as we just heard from the insurance department, they're actually not supposed to. And in fact, sometimes they don't. So now you're in a situation where your client has been offered $50,000, which is less than what you've told them that their claim is worth. And as an attorney, you ethically cannot recommend that they take that settlement for $50,000 unless you know for a fact that's all the money that's available. So now what happens is you have to draft a lawsuit on their behalf. That'll take a few weeks. You file the lawsuit with the court, pay $300 odd, $280 in filing fees to the court. You give it to the sheriff, pay the sheriff to serve it on the defendant. Some person in their house gets served by the sheriff, even though they're insured. Then you go into court. The insurance company has to hire a lawyer. They file an answer. And then a month later, under current New Hampshire statute and court rule, they are then required to tell us, hey, the insurance policy limit's only $50,000. That's all you can get. And then you settle the case for $50,000 because that's all you can get. You could have avoided that, drafting the lawsuit, waiting weeks, serving with the sheriff, having to interrupt some poor person at their home, even though they have insurance, weeks waiting in the court system, burden on the court, insurance company having to hire a lawyer, all to reach the same result. Because under current statute, which is 498:2-A, once suit is filed, the insurance company is required to disclose their policy limits. We're just asking that we go back a few weeks or months to the moment where we're trying to settle the case without having to go through all that trouble and require them to disclose it then. That's all we're asking for. And it really doesn't make much of a difference to lawyers. We get paid the same no matter whether we settle 2 months ago or 2 months in the future. It makes a difference to our clients because A, they have to pay for those court costs, which are not a lot, but it's a few $100s to file a lawsuit and to pay a sheriff to serve the lawsuit. And it makes more of a difference because of the time to draft the lawsuit, to have it served, to wait for the insurance company to hire a lawyer and respond, and then finally disclose that information we should have had a couple months ago. And these people often are living paycheck to paycheck. They haven't worked for a long time. They have medical bills that might be going to collections, and they need the money. And all this bill would do would be to help them get that money, which they're going to get anyway, a little bit sooner. So I really think it's a common sense fix. It's a relatively minor fix that just speeds up the process by a few weeks or months and helps get money into injured people's hands that they're going to get anyway a little bit quicker. I'm happy to answer any questions.
Representative Burrows.
Thank you. I just have a quick question. Thanks for taking my question. The example you gave where the insurance company had a $50,000 limit. What if somebody has an accident and they have $3 million worth of medical bills? They cannot get more than 50,000?
Well, and I won't go into a lot of detail about underinsured motorist coverage, which the representative from the insurance department talked about. If the person who is injured, if I'm uninsured and I'm hit by someone else and they only have $50,000 in coverage, in most cases, yes. Now that's an extreme example with $3 million, a catastrophic type injury. And those situations, a lawyer will still do their due diligence to make sure that there's no other assets that the defendant has. If they own multiple houses, for example, or they're somehow rich in some other way, there's no rule that you can't go past that insurance coverage limit and pursue them personally. But what happens in practice is if someone only has $50,000 of coverage, they probably don't have multiple houses. They probably don't have a bank account with $1 million in it. And they have protection under certain laws, including bankruptcy laws, that make it really unfeasible to get more than that $50,000 limit in almost every situation.
Thank you, and that's horrifying.
Representative McAleer.
Thank you. Just a quick question. You mentioned uninsured. How about underinsured? And in this case, if I had $1 million worth of my own liability coverage and he only had 50, could we dip into that?
Absolutely. And so, again, the way that underinsured coverage works is typically that it only kicks in. Again, the insurance department representative, I think, misstated things. It's not the first line of defense. Legally, it's the second line of defense. You're required to exhaust the tortfeasor or defendant's insurance coverage before you get to dip into your own coverage. It's a backup. And so what would happen in that situation is, again, you still need to have that insurance coverage limit information in order to settle with the tortfeasor or the defendant first before you get to dip into your own coverage. So this bill would help in that situation too, where right now you might have to actually bring a lawsuit, waste your time getting that $50,000 before you realize you have to turn to your own insurance. If this bill is passed, that information gets disclosed up front and you immediately know, hey, I need to make an underinsured claim against my own insurance. This person doesn't have enough.
Okay, thank you very much.
Thank you.
Chair will call on Lindsay Nadeau.
Good morning, Chairman Hunt and members of the committee. You get me today instead of George. My name is Lindsay Nadeau. I am an attorney at Oren Reno here in Concord. And we represent the state trade and the national trade groups for the property and casualty insurers. That's the New Hampshire Association of Domestic Insurance Companies, as well as the American Property Casualty Insurance Association. And we are here in opposition to Senate Bill 423. I just wanted to clear one thing up. I don't think currently there's an issue in practice. And I think it's undisputed, and there's correspondence from the bill proponents and testimony, and also from industry, that the majority of the time, if there's a legitimate request pre-lawsuit for a policy limit disclosure, that information is voluntarily provided already. Now, are there times when perhaps the information isn't provided? Yes, but there's good reason for that. And we don't think mandating policy information, no questions asked, is a good policy decision. So we'd ask you not to vote for the bill. So as initially drafted, as you heard, the bill allowed anyone to make a request for any reason to any person or their business about their policy limits. It then was narrowed down to just auto liability policies. This is still, in our view, an unnecessary burden and frankly just a violation of privacy to those businesses and individuals carrying auto liability policies and umbrella policies. It's in the interest, as you've already heard, for all parties to settle cases without the expense of litigation and having to hire attorneys. Claims get settled every day without attorneys involved. I've had them personally. I've been in an auto accident. I did not have to hire an attorney. So generally, this is not a problem. The information is voluntarily provided when there's good reason to do so. So for example, when a claimant's injuries are valued higher than the policy limits, it may be in the insured's best interest to disclose the policy limits to help expedite a faster resolution to a claim and allow the claimant to pursue their uninsured, underinsured motorist coverage. And that's typically when these situations come up. So if you have $200,000 in damages and a $50,000 policy limit, the insurer is going to say, it's a $50,000 policy, go use your own UM coverage. But claims should really be based on alleged injuries and damages. Your policy limit really shouldn't come into play. A mandatory disclosure of policy limits may actually become an impediment in resolution if the plaintiff's lawyer is aware of a high dollar policy limit and then focuses on that limit rather than their actual damages. So keep in mind also that whether to disclose or not to disclose is really up to the insurance company, whose duty is to protect their insured. It's not to serve the interests of a potential claimant who's seeking to sue you. So from the company's perspective, that relationship is between the company and their insured, and that's where their duty lies. And I think that's where it came up. Mr. Fox mentioned INS 3000, and as part of that duty, there's confidentiality requirements. And insurance companies can't just go around giving out your personal information, right? And under the regs, there are times when they can disclose that information, and that would be these scenarios. So this bill would conflict with that because the insurer would have to give out the information even if you don't authorize them to do that. And James Fox will correct me if I misstated that. So if there are rare situations when a company is not disclosing a limit for some reason, like if liability isn't clear or a claimant hasn't provided a legitimate reason for requesting it, a claimant may file a lawsuit and will automatically receive that information as part of the discovery process very early in the litigation. Court, and we already heard there's a statutory requirement, and then there's also state and federal court requirements. This bill is really one-sided, and unlike in a number of states, a potential claimant is not required to produce any information about the request. They can just say, show me your limit. They don't have to provide you any information about their damages, a police report, medical records, grounds for liability. There isn't a strict confidentiality provision. There aren't any clarifications in this bill that the information can't be used if the case does go to court. These are all mutual disclosure requirements that we often see in the minority of states that do have a pre-suit mandate. There's a mutual disclosure requirement. That's not what this bill does. It's completely one-sided. Transparency is a two-way street. So if a potential defendant is required to disclose information, then we believe a potential plaintiff should also be required to do the same. The majority of states, remember, do not require pre-suit disclosure of policy limits. New Hampshire protects its privacy. We have a constitutional amendment on privacy, and we feel like this is an invasion of those privacy rights. Frankly, it's no one's business how much insurance you carry. If this bill were to say, how much do you have in your bank account, I don't think you'd be in favor of that. And that's essentially what this bill does. It invites fishing expeditions so that you know how deep someone's pockets are. So in most states like New Hampshire currently, the nature and amount of insurance that you carry is private. It's not subject to public disclosure. And we believe that status quo should be held. So the bill would subject people and businesses to the burden of contacting their insurance agent or their company to confirm their coverage, guess what coverages might apply without even potentially knowing what they're accused of doing. And therefore, we believe that any utility of the legislation is outweighed by its costs, and we hope that you will find it inexpedient to legislate. And I'm happy to take any questions.
Thank you for your testimony. Any questions from the committee? Okay, seeing none, thank you.
Thank you.
Next, we're going to call up Heather Menezes from NHAJ. And you support the bill and you request 2 minutes.
Thank you to the committee. Again, my name is Heather Menezes. I'm an attorney with Shaheen and Gordon. And I thank you for the opportunity to speak. And I am speaking in support of this bill. To help you understand a little further, I am a personal injury attorney. So I'll let you know how the process goes and then why this bill really is necessary. Say somebody comes in there in a car accident and they're injured. We investigate that claim. I don't take a retainer. I do all my cases on contingency fee, as most attorneys like me do. So we have to investigate. We get their records. I get their records from before the accident to make sure they're not already experiencing these issues. And then we make a claim with the insurance company. Now, most insurance companies are not the ones getting fined, like Mr. Fox said. Most, they negotiate with you and we're able to resolve a case. And, you know, the value of the case is what that investigation that I put into it. It's not dependent on what the policy limits are. So why do we need them? What's the big deal then? So this is where the issues come into play. One, where you've got, say you've got someone very seriously injured and I'm doing my due diligence. I'm getting all the records, all the bills. I am providing them. This is not one-sided. I'm giving all this information to the insurance company. And I'm doing all this work. Say the person only has 50,000 in coverage and they have 100,000 in medical bills. Why am I going to keep doing all this stuff if there's only 50,000? And I have had to file suit because they wouldn't give up what the policy limits were, only to find out, well, why didn't you just tell me this? But the most important impact, I think, and it's as Mr. Fox explained, Representative McAllen also mentioned, is underinsured motorist coverage. And again, you have underinsured coverage if someone causes you injury. And you say you have $1 million umbrella coverage yourself. If you don't know how much coverage that person who caused your injury has, you don't know whether you have an underinsured motorist case or not. You can't compare unless you know. And I've had to file a lawsuit because the insurance company hasn't done that. I had a case where the person themselves had $1.25 million in coverage. He had a permanent brain injury and will never work again. Insurance company wouldn't tell me. I had to file suit because I literally could not determine whether he had an underinsured motorist coverage. And under the court rules, you get them automatically. You don't even have to request it. You get what the policy limits are. So it was a waste. It was an absolute waste. It wastes the burden of the court because now they have to give you a docket number, jury trial date, all of that. We have to spend the money to file the lawsuit. But then also you want to talk about privacy? Who's the defendant in that lawsuit I filed? The individual. The insurance company is not on the other side of that V. That is Mr. Jones, who caused the accident, is now public record. Anyone can look that up and see he's been sued. There's your privacy issue right there. Meanwhile, if the insurance company had just said, oh yeah, well, they also have 1.25 million in coverage. I know I have no underinsured motorist claim now, and I didn't have to file that lawsuit. That's why this is necessary. The attorney before me said, yeah, a lot of times this is voluntarily done. Yes, it is. And it's a very simple process. I request the policy limits and they just give them to me. It's not burdensome on the insurance company. They have that information. And it's not as though I say, oh, I think this is a $50,000 claim. Oh, you have $1 million, now it's $1 million claim. It's not $1 million claim. It's a $50,000 claim. And we never even touch the rest of that coverage. That's how that goes in practice. And I'm happy to answer any questions about how this goes in practice.
All right, thank you very much. You have a question, Representative Porcelli?
So can you thank you for taking my question. So can you tell me what protections there are legally to make sure that you're not, when you get the information about the insurance limits, that you're not trying to increase the value of the lawsuit? So if you only have 50,000 and then you find out the other party has $1 million, you say, okay, we're going to get a big payday. What are the processes in place that would prohibit something like that?
So I would say the processes are the fact that the insurance industry, they're smart people, right? And we have to prove our claim. So if I make a claim, say it's really only a $50,000 case and it's $1 million policy. Say I make $1 million demand, they're not going to pay it. They're going to say, where's your evidence? And if I don't have it, that case isn't going to settle. And as a practical matter, as a personal injury attorney, I substantiate every demand that I make. I don't just say, I want $1 million. I say, look, here are the elements of my claim. Lost wages are X amount, and I write to the employer to get substantiation for that. Medical bills are this amount. Here's all the bills. Here's all the medical records. And this is an exchange. This is not a one-way street. It's an exchange. We're giving a lot of information to these insurance adjusters pre-suit for them to be able to make a determination as to what the case should resolve for. And they're smart. They're good at their jobs. They've settled cases before, just as I have. And that's how the process goes. And no attorney worth their salt is going to make some ridiculous demand because they know they're not going to get a response to it. And I think that's where the protection is that the industry knows what it's doing. And attorneys themselves aren't just going to make some crazy demand because then nothing's going to happen. And it'll be a waste of everybody's time.
I have a question. Currently, the attorney doesn't know the policy limits, most likely, before they accept the suit, right? Before they take the case.
Correct.
Right?
Usually.
So so my question is, if let's say someone has $1 million legitimate claim, but the policy limit is only 250,000, so there's 750,000 above the claim, and the attorney knows that in advance before they accept their client's case, wouldn't it be harder for someone to get an attorney to accept the case if the attorney knows in advance that the claim is far beyond the policy limits? Because it's much harder to get assets from someone than it is a payout from an insurance company. There's a lot more work for the attorney. So couldn't it unfairly advantage the attorney to know that information before they accept the case, because they would accept easy cases and maybe not accept more difficult cases where assets are required?
Right. And I think I understand your question. If as I answer it, it's clear I'm happy to try again. But so the situation is that there's only 250,000 in coverage, but there's $1 million in damages. And so what happens with that person? Honestly, I've had cases where if we know what that coverage is, I don't take the case. I don't take the case just to take the 250,000 if the person could have gotten it on their own anyway. So that's one advantage there, is that person then, if that 250 is offered to them, they don't need me.
Yeah, so I'm sorry, that was my question.
Okay.
So there's $1 million legitimate claim, like in the metaphysical world, that person deserves $1 million,
Yep.
but there's only a small amount of coverage. The attorney knows that before accepting the case. They may not accept that case. That person may have a harder time getting an attorney.
So I see what you're saying.
what I'm saying?
So I think it's going to depend on the circumstances, but if that's something then we learn, for me, I would just have the person take the 250 if we know that that's all that's there and the insurance company just pays it and there's no litigation. Now, if the person wants to investigate, are there personal assets? A lot of people don't know they have underinsured motorist coverage as well. They know, oh, well, I know I have 250 and a $1 million umbrella, but that's liability. They don't know that in New Hampshire, you automatically have underinsured coverage. And a lot of time we can also look more broadly too to see what other insurance does exist. So, you know, I think it depends on the circumstances. It depends on what other assets might be available, but I don't think it would hinder, I don't think that situation would hinder that person getting an attorney to get what they would deserve. If they are being offered the 250 and we know that all there is 250, I will tell you I wouldn't take the case because I'm not just going to take a 1/3 contingent fee on something I'm not going to do any work on. The person would just make the claim on the other person's insurance company and get the max they can get.
Thank you. Representative Burrows.
This is a would you believe question.
Okay.
I know that many insurance, and your firm may be different, in law firms who handle these kinds of cases routinely, the first thing they do is figure out how much money is involved. I mean, that's just a fact. My husband has done a lot of work for these firms, and if there's not enough money in it for them, they refer them elsewhere.
I don't want to speak to other
No, I understand
attorneys,
that.
but
I understand, but it is a routine practice. Yeah.
That's what you believe. Representative Grassley.
Yeah, I certainly sympathize with your situation here, but I'm looking for something that basically makes a little more sense, because I can understand that if somebody just came in, somebody was in an accident, and the first thing they want to know is what the insurance limits are, so they can maybe game their case to get more money, whether it be $50,000 or $60,000 or $5 million. Is there any way that we can put an amendment into this bill that would say that they have to disclose? You know, I understand that when you make a claim, a lot of them voluntarily will disclose what their limits are. But what we do is we make it a requirement that when you make your claim, so you're putting your money, you put your cards on the table first, and then they're required to put their cards before going to court. Because I think going to court is senseless in this if we can settle out of court. And that's what we're trying to do here. I think this is what this bill is trying to do. And I think that if we could put some sort of trigger in the law that says, when you file your claim, that's your claim. They can now come back at you. They can tell you what the limits are. And so then you can start working, and it would probably keep you out of, in 99% of the cases, it will probably keep you out of court.
so I think the protection is the alternative. What you're saying is fraud. Attorneys can't do that. I don't do it. Most attorneys, I think, don't do it. And again, I'm going to go back to the insurance industry, and the insurance adjusters are very smart and knowledgeable. So they'll be able to smell that a mile away for sure. If someone is just padding something to go to I mean, someone goes to their doctor makes recommendations. And if it becomes pretty obvious if things aren't legitimate, because everything has to be substantiated with medical opinion for injuries or lost wages with, usually the employer or something. And I think the insurance industry is very good at what they do. And if there was any hint of that, then they would know that.
Thank you very much.
Thank you.
Chair will call on Joan Pagano from the Big I.
Good morning. Chairman Hunt, members of the House Commerce Committee, thank you for allowing me to speak this morning. My name is Joan Pajot. I'm the president of the Big I of New Hampshire, representing the independent insurance agents throughout our state, and we strongly oppose Senate Bill 423. When this bill was brought forward, it pertained to all lines of insurance. When our association, along with many other businesses and associations, stood together and opposed this bill, they amended it to include only automobile. We continue to strongly oppose this bill. Insurance has been my chosen career since 1979, and I've personally been involved in an auto accident, and I've been treated fairly by the insurers that were involved. I don't believe mine was the exception. I believe insurance carriers treat their insureds and claimants fairly. Our insurance processes work because of that underlying fairness. I'm not an attorney. I'll start with that. And I have nothing against attorneys. Some of my closest friends are attorneys. And it's my understanding, and it's been brought out several times, that when a suit is filed, the insurance limits must be provided to the claimant's attorney. This makes sense to me. This bill makes it a requirement, subject to a penalty and attorney's fees for noncompliance, to provide liability coverage limits, which would include umbrella limits because they're an extension of the automobile limits, before a suit has been brought. That doesn't make sense to me. I believe it's unwarranted, an invasion of privacy, and for a lack of a better term, a fishing expedition by the attorney. Let me give you an example. 2 car accidents happen. Same scenario each time. A vehicle is rear-ended, and the injuries are the same. First, in both instances, the person struck, the claimant, under this bill, can now demand to know your liability limits. No suit being filed is necessary. In the first crash, the at-fault driver carries minimum liability limits. $25.50 for bodily injury. In the second crash, the at-fault driver carries $250, $500 limits for bodily injury, plus a $5 million umbrella. Whose case do you think the attorney is going to take? Proponents of this bill have said the passage will streamline the court process. That doesn't make sense to me. I believe it's naive to think that this bill could streamline or reduce the number of lawsuits. I believe what it will do is undermine the insurance process that works here in New Hampshire. What it will do is cause unnecessary work for the hardworking insurance agents who will have to field demands for coverage limits. What it will do is take away the opportunity from the independent insurance agent to advocate for their clients with the insurance carrier. Because once an attorney is involved and retained, the agents are taken out of the process. So even though they want to help their clients, they want to be their advocate, they can't. So on behalf of those thousands of hardworking independent insurance agents here in New Hampshire, I respectfully ask that you vote Senate Bill 423 inexpedient to legislate. I thank you for your time, and I'll be happy to try to answer any questions.
I guess we're all set.
Thank you very much.
Chair will call on Marissa Chase.
Checking to see that it's still morning. Good morning, representatives. For the record, my name is Marissa Chase. I'm the Executive Director for the New Hampshire Association for Justice, which is a euphemism for Plaintiffs' Trial Lawyers Association. We are in support of this bill. I just wanted to make two brief points. In Senator Carson's opening statement, and I went back and double-checked this, she was citing a narrative from an insurance defense firm advocating for policies such as Senate Bill 423 contains. The insurance defense firm, I emailed that to the committee. Their 50-state survey. It's Matheson, Wickert, and Lehrer. They're a national civil defense firm. I wish we had some more insurance defense lawyers here to testify and explain how the process works. I will share that when I have spoken to them, they would agree that we thought this would be a no-brainer. I understand that there are some concerns. I would note that this started off in Senate Judiciary, and perhaps Judiciary is a better committee that is more familiar with how the legal process works. So I understand the questions you have, and I hope that our members are doing our best to answer those questions. That's all I wanted to say.
Fair enough. Any questions from the committee members? See none. Thank you very much.
Thank you.
Okay, Kirsten Schultz from State Farm.
Good morning, Mr. Chairman and members of the committee. I'm Kirsten Schultz. I'm an attorney with Nixon Peabody based here in the Manchester office. Some of my practice actually does include insurance defense, but I am here representing State Farm, one of the leading writers of auto and home insurance in the nation and also here in New Hampshire. We're here to oppose SB 423. You've heard from others today and likely may hear from more about the reasons that we oppose this bill. We have to share some of their concerns. And I will submit written testimony for the record as well this morning. But just to summarize its main points and without repeating too much others' testimony, as a practical matter under current law, legitimate claimants can and do obtain information about liability coverage limits in the normal course of a claim at the proper time. And State Farm has a lot of experience working with similar bills in other states and has identified a list of problems with this bill. First, as it's written, SB 423 could incentivize targeting of people who purchase insurance. So people who make the responsible decision to enter into private contracts for the purchase of insurance. And it does raise concerns that claimants' demands will be, I call it reverse engineered, meaning they will be calculated to reflect the full amount, or at least approximating the full amount of insurance coverage that may be available, rather than the amount that really properly reflects the alleged damages suffered by the injured party, which are wholly independent from the existence or not of insurance coverage. And to be clear, I want to be clear that some lawyers do this. Lawyers definitely do this. I will exclude from that group the very well-respected members of the plaintiffs' bar who sit in the first row here, who do the work to substantiate their clients' claims, but not all lawyers do that. Unfortunately, it would make my job easier if they did. Others seem to just say, you know, show me the money, where's the money, without doing the work necessary to substantiate those demands. And State Farm has seen also some instances. For example, there's a law that was fairly recently passed in Colorado that's similar to this one, where State Farm has noticed instances where requiring disclosure has actually generated medically unnecessary treatment because attorneys kind of push their clients to go receive additional medical services to pump up the valuation of their claims. So second, the bill also will likely create some confusing overlap with existing court rules and statutes that require disclosure of the same information post initiation of litigation and with different timeframes. So right now, claimants are entitled to insurance policy information after they've filed a lawsuit. And by the way, filing a lawsuit should only be done for legitimate meritorious claims, but it's not hard. It's something that any person, any pro se plaintiff can do without an attorney if they feel like filing a 2 or 3 page complaint or more or longer with the court and paying a small filing fee. But the beauty of it is that by filing a complaint in court, the claimant or their attorney is essentially certifying to the court that the claims that are involved in that lawsuit are properly grounded in the law and in fact, and they're not frivolous. But yes, insurance information is among the very first categories of required disclosures in both state and federal courts. The bill, as it's written, though, seems to allow anyone to obtain that same otherwise privately held policy information on demand without any corollary requirement that the request be made in good faith. The third problem that State Farm sees with this bill is that it contains no or only minimal threshold requirements or guardrails against frivolous or unmeritorious claims. We've talked a little bit about how the bill is very one-sided, and the most recent amendment adds some minimal guardrails on the use, for example, of disclosed policy limits by saying that the claimant or claimant's attorney shall utilize the disclosure only in connection with the claim or lawsuit. But there are no penalties associated with failure to adhere to that provision. And if you look at how other states' statutory or regulatory frameworks deal with pre-suit disclosure policy limits, among the several states that require any pre-litigation disclosure of liability policy limits, and by the way, the numbers that I have for how many states actually require these things and to what extent seem to differ pretty substantially from the numbers that Senator Carson had cited earlier and others. So, but among those states, many of them impose pretty substantial threshold requirements that are absent from this bill. For example, a claimant has to provide certain documents or evidence supporting their claims. Confidentiality protections apply to disclosed information, protections against unnecessary disclosure of excess or umbrella policy information. Some states would also restrict to automobile insurance coverage, but they may also exclude, for example, fleet coverage. So there are other considerations. And I do want to note that it saddens me to hear Senator Carson say that the insurance industry was unable to compromise, but I want to specifically note that State Farm did not agree to the amendment language making the bill applicable to auto policies only. They feel that improperly targets entities like State Farm that are primarily auto insurers. But so just to be clear, under current New Hampshire law, our state is not an outlier It's relatively few states, about 18 plus DC, that require any pre-suit disclosure of liability policy limits by our research and experience. And among these, most states do impose these threshold requirements. It's also notable that about 18 other states that have such a law ensure that the severity of injury warrants the disclosure. So I think in Virginia, for example, the plaintiff has to prove that their medical bills will exceed the minimum limits for coverage. This bill doesn't have any such provision. There's also a bill in Delaware that is one example of a better alternative. And fourth, and finally, the penalties in the bill are potentially severe for insurers, and they're one way only targeting the insurer. We're subjecting an insurer to a financial penalty for failure to comply, which could encourage some gamesmanship. It's not clear when the 30-day period exactly might start, how many letters can the person send to trigger it. There's no penalties, again, built in for claimants or claimants' counsel's misuse of the policy info. And the $500 penalty, I think it was $500 the last time I looked in the New Hampshire bill, is pretty severe. And there are perhaps only other, I think, 3 states that impose penalties like that. New Hampshire would be an outlier if it did something like that. And so for these reasons, we oppose the bill and ask the committee to do the same. And I'm happy to answer questions if it would be helpful.
I think they're all questioned out.
Okay.
Thank you.
Thank you.
Chair will call on Roger Turgeon.
Oh, red is good. Okay. Red is usually bad in my business, in anybody's business. Thank you again, Mr. Chairman and members of the committee. My name is Roger Turgeon. I live in Dover, New Hampshire. I've been a trial lawyer for 43 years in New Hampshire, Mass, and Maine. I happen to be governor at large of the NHAJ. Our organization at any given time represents perhaps 10 to 20,000 citizens of residents of the state of New Hampshire involved in tort claims. I speak in support of 423, not just for the NHAJ, but personally. I don't have much skin in the game. I'm going to be retiring anytime. I'm speaking on behalf of those people who will be injured and have claims coming up in the future, but they don't know who they are yet, so they can't be here to speak to it. They don't know they're going to have an interest in this. I support 423 because it's mainstream. It's a pretty common type of legislation across the country. And in New England, we are the only state that doesn't have a disclosure requirement like this. 2 of the states are motor vehicle specific, Connecticut and Vermont. And the other 3 states have broader disclosure requirements than we do. So it's mainstream. It just makes common sense. It costs nothing to the insurance companies, whatever you've heard about, agents might be burdened by having to responding to these things. I can guarantee it's not agents. The bill talks about insurer. An agent is not an insurer. We know who the insurers are. We know who the claims people are. They're the ones who are required to make the disclosure. I guarantee you that whenever a claim comes to an adjuster's desk, one of the pieces of paper that's been disclosed to that adjuster, actually it's not paper anymore, it's on their screen on their computer, is the policy limits. They're not surprised by it. They don't have to do any extra work to look it up or to tell anybody upon a request. So it costs nothing. It does save litigation. As Israel Piedra said, it is not an earth-shattering thing. This is not going to change the lives of thousands and thousands of people in New Hampshire. But there are occasions where, because the claimant can't find out the policy number, the policy limit, or the claimant's lawyer can't find out the policy limit, we have to file a suit to find out what that number is. That represents a small expense that's going to be passed on to the client. It represents an expense for the insurance company that's greater because now they have to hire a lawyer, or they're paying You know, they've got a lawyer on salary whose hours are taken up by dealing with the litigation. Litigation has to go through some stages for about a month or so before you get to the Rule 22 disclosure requirements. By then, you're talking about who's our mediator going to be, what's the timelines for discovery, how many people are we going to be talking about as witnesses? Oh, and by the way, what's the policy limit? So a fair amount of work has to get done to get to a simple piece of information. So it will, on occasion, avoid a piece of litigation that would otherwise be unnecessary. Not a big deal, but it's a help in those cases where it becomes important. And to be honest with you, it supports the very collegial atmosphere that New Hampshire, we love to brag about, and it's true, how collegial the atmosphere is between plaintiffs' lawyers, the defense bar, and the insurance adjusters. We deal with the same lawyers and the same adjusters on the other side all the time. You know, I have had thousands of cases in my career, and I've probably dealt with 50 different adjusters and 20 or 30 different lawyers. Our reputations with each other mean a lot. So the gamesmanship you hear about, the reverse engineering you hear about, that we're going to reverse engineer our cases, I don't do that. I don't know anybody who does. I can't say that nobody will do it, but the people who are going to do it because of the disclosure requirement, they're going to file suit and they're going to do it anyway. You know, the fact that you tell them early, what I can tell you is one thing. I've had any number of situations where, and not involving my cases, where insurance carriers are not often shy about reaching out to injured parties. Their insured contacts them, says, I was in a crash yesterday, what do? They get the information. The information includes who's the person who got hit. And before you know it, the person who got hit is getting a phone call or a letter from the insurance company saying, we want to do right by you, let's talk. And they make settlement offers. If they were to disclose the policy limit and they could make it and still make a settlement offer and get a case settled, that's great. If they don't disclose the limit, then that person comes to me and ask any insurance agent, any insurance industry representative, and they have the statistics. How much more do they pay out on average on claims where people are represented by lawyers than on claims where people settle their own cases with the adjusters? So it's actually to the insurance company's benefit to disclose. In most cases, will a smaller limit be disclosed for the sake of getting the case over with? Yes. Will there be cases where it's not disclosed? Because I'll call adjusters when a case comes to me. I'm not going to do all the research ahead of time, but if I already know that the person's been in the hospital for a month or they've got $20,000 or $30,000 worth of bills, I'll call on adjusters. Hey, Jim, I've already got $20,000 in bills. The guy's still treating. It's a pretty serious injury. Can you tell me what kind of a policy you got here? Because if this is going to be a $25,000 settlement, let's just do it quicker. It's easier and cheaper and quicker for everybody. And if they tell me they do, you know, I got to do my due diligence and see if there's other policies and things like that. But almost all the time, the cases end up settling within the policy if you know. But if you don't know, then you do have to file the suit and those other things happen. So I'd like to think that we have a very collegial atmosphere here. I do practice in other states where it is a mandatory disclosure. It's been mandatory in Maine for 15 years, and it's been mandatory in Massachusetts for almost as long as I've been practicing, maybe even since before I was practicing. I don't remember when it went in. What I can tell you is it's never been an issue. I mean, it doesn't cause any problems. No plaintiff's lawyers act any differently on account of knowing, except we do reverse engineer the value of our cases and are willing to settle based on the policy limit in one situation where the policy limit is smaller than what we think the case is worth. We will almost always agree to take a policy limit settlement rather than pursue personal assets or something along those lines. In 40 some odd years and thousands of cases, I've seen it's either 4 or 5 cases, and not all of them mine. I've seen 4 or 5 cases in which the lawyers, pursued assets or something beyond the policy. One or two of those were mine, and the others were colleagues and partners and such. So we do reverse engineer in the sense of taking less than the case is worth if we know the policy is, too small, as long as we've done our due diligence to make sure that, we're not missing out on another policy or something along those lines. I could talk, but I'd rather just, if there are any questions, I've heard some intriguing questions. I think it's a very active panel here. I think that's great. I'd love to, if any of the questions you've asked haven't been answered to your satisfaction by others, I'd love to take a shot at them for you. Other than that, I will stop. Thank you for listening.
I think they're all set.
I guess they're all set. Thank you much.
Thank you. I got one card left. Mike McLaughlin, representing Allstate. And you're going to do 3 minutes, right, Mike?
Probably less than that.
All right. You'll be the man.
Good morning, Mr. Chairman and members of the committee. My name is Mike McLaughlin. I'm a lawyer and lobbyist in Concord, representing Allstate Insurance. I'll try not to repeat what's been said before, but through my personal experience with insurance, I've had a few car accidents, and one of the most interesting things is when the police come to the police report, they take your name, they ask you for your insurance card. Even though we don't have mandatory insurance in New Hampshire, they do get the insurance card. I can talk to that personally because the last 6 months, in June, I had a car accident, not my fault, of course, but they did get the insurance card from me, so the people had the information available right then and there. The thing that I find troubling about this bill is, how about a multiple car accident? 3 or 4 or 5 cars pile up on 93. You have A, B, C, D, E, F, and G looking to, does G get H? Does F get A? Who gets what from who? The dynamics of the New Hampshire insurance market, commented earlier on by the insurance department, I agree with that. And people keep saying, we're the only one who doesn't have this, we're the only one who doesn't have that. Those are the dynamics in the New Hampshire insurance market which keep our rates as low as they are. And in the automobile claim world, with the expensive cars as they're coming, insurance premiums are getting higher and higher. So anything that changes the marketplace will probably have a negative effect on premiums. The other part of the bill, which I think is kind of remarkable, is the restricting the information only to automobiles. I do not want to see it broadened as was in the Senate. But what's the difference between a broken leg in a Chevy or a broken leg falling down a faulty flight of stairs? The claim is a personal injury claim, but if it happens in an automobile, they want to get the information. We don't see the need. We see the dynamics in claims and settlements as illustrated by the insurance department be the back and forth that keeps a claim reasonable. And New Hampshire has been very good in reasonable recoveries, just recoveries for many, many years. So we oppose the bill. We like the system as it is, and we think it's working well. Thank you.
Thank you very much. Having no more cards, I will close the public hearing on 423, and we are half an hour late. Good thing we deleted that other bill. Just because think how long that one took us yesterday. So, all right. And I do have a card from Senator Prentice. You ready? Okay, we're ready. Senator Prentice. We'll introduce her bill.
Thank you very much. Good morning, Chair Hunt and members of House Commerce and Consumer Affairs. Long time no see. I am here to introduce Senate Bill 556 as amended. I trust you have the amended version. This bill prohibits insurance reimbursement solely based on participating providers' licensure. So very briefly, when we originally introduced this, it's been based on a problem in New Hampshire where we don't, well, actually a problem nationwide, but specifically this applies to New Hampshire where we don't have enough primary care providers. Primary care providers services are either physicians or nurse practitioners. And they serve as what I refer to as like a traffic cop. When you have a PCP, they see you, they make decisions about what referrals you may need for whatever your complaint or condition is. There's some cases where you don't have to have a referral, but a lot of the medical conditions and specialties, like just to get an MRI, you've got to have a referral. So over time, what has come to bear is that we don't have enough physicians that are primary care physicians. So the nurse practitioners who are independently licensed to practice, just like the physicians, have been acting or working as PCPs, providing the same services but not reimbursed the same way. And just, quickly, and it's not with any disrespect to the physician community, it's just, this is a nationwide problem. My mother, who is now 92, and she doesn't like when I say that, moved to New Hampshire 2 years ago and could not get a primary care physician. And we live in, like the home of healthcare in New Hampshire. So she chose to go with a nurse practitioner and loves her nurse practitioner. So with that being said, we were initially seeking to bring parity in payment for services provided, the same as physicians. Right now, with the exception of Anthem, who does reimburse for primary care and behavioral health at 100%, health insurers are primarily following the CMS guidance, which is that nurse practitioners are reimbursed at 85% of what the physicians are. So during discussions, we initially had passed it with parity, but it wouldn't work based on all the different types, all the different carriers. And we were looking at amending the Nurse Practice Act versus really, and with the thanks of Heidi Kroll and the insurance providers worked towards amending the statute, which is 420J, which has to do with provider contract standards instead, to try to incrementally get us to where I think ultimately we need to be, is for same services, same pay. But for now, the position is, let's highlight this and provide clarification in the provider contract standards so nurse practitioners, especially the ones that are the leads for practices, they can actually point to this in the law and negotiate with the different insurance companies to get a better rate and ultimately get the same as physicians, which is 100%. So that we introduced it for parity, we amended to bring clarity. I thank both the nurse practitioners and the insurance carriers for getting at the table and trying to find a solution to this so we can, do better by our Granite Staters in terms of primary care and including, just general primary care and behavioral health. And those are my opening remarks. I'm happy to take any questions you might have.
Representative Spear.
It says on line 4 that reimbursement provisions based solely on participating providers' licensure.
Mm-hmm.
What do I do with solely? I can't figure out, as someone trying to evaluate legislation, what do I do with the word solely? I mean, I don't know what to say.
Well, thank you for your question. But as it is right now, licensure is used in reimbursement for primary care and behavioral health based as the criteria by which reimbursement is made. So what I am asking, and I again worked with the insurance carriers, is to change that so that when they are negotiating, they can't use that as the primary decision maker.
Clarification, please.
So let's talk about the word solely.
Okay.
Okay.
Okay. So solely is a very famous word in this committee room.
All right.
And it goes back to that when the issue we've always had was auto insurance rates, and that auto insurance would sometimes use your credit report as to decide on what they're going to make for you an offer on insurance. So we've had this legislation. We've had many times where the issue came in. What are we going to do? What are we going to do? And there came that word solely, because an insurance company, when it makes its reimbursements rates, whatever it's going to reimburse, it has to have data behind it to why it uses, whatever criteria it uses. It has to prove that that criteria is a legitimate criteria. And so the word solely was a sense that you were not going to get your insurance rate simply because you had a bad credit report. There had to be other things in there. So in this case, it would be that they're not going to solely reimbursed because it's a nurse practitioner. They're going to use other statistics such as your degrees or how many years you worked, all these other things. I would say over the past years, we used to have a big thing about being board certified. and that physicians had to be board certified, and that was a criteria. So over the years, these issues of what is an insurance company can use for setting that rate. Now, normally, when it comes to the primary care physician, the rate is really somewhat set based upon where they are, where the market area is, and what's the going, what it has been for other primary care physicians. But in this case, they're saying it based upon your practice. So it's not just a primary care, in this case, it's not just primary care and nurse practitioners. It can be anything. The way this says solely is that it can be anything the health insurance carrier, when they're going to reimburse and whatever rate they're going to agree to, whatever they're going to offer. And this is negotiated, by the way, that they're going to have to show that there is some statistical history about why they got to the number they got. So that's where the word solely comes from.
So you're saying it actually has a real meaning? Because it seems to me that just the way this is written, without anything in there, it could be because your hair is brown. I mean, anything.
They would have to be able to show statistically that someone who had brown hair.
Does it say something in here about that, having to
That,
show
again, let's say that's an inside, how insurance is done. So yes, this word, this way this is written, has deep meaning in terms of the department, and they'll come up and tell you. Okay, they will testify, but it absolutely has meaning, and that is when you're negotiating the rate, they can't simply say, well, you're a nurse practitioner, so we're going to pay you less simply because you're a nurse practitioner. They cannot use that. Yes,
Thank you.
Representative Hammond.
Thank you for taking my question. Thank you, Mr. Chair. Question about leveling of costs, right? So if you have different license types that are getting reimbursed differently, and you have to ignore, the insurance company has to ignore the license type, how do they level those costs between, different license types that have different levels of training?
We do have someone from the insurance department, so
Okay.
I think they can take that.
All right.
Thank you for the question. We have someone from the insurance department. I think that's great. I was like, whew.
That's right. Okay, any other questions for the senator? Yes. Representative.
Thanks for taking my
Burrows.
question. As the chair mentioned that, they need to rely on data to come to these conclusions. And I'm reading, frankly, I was pleasantly surprised to see that a lot of studies show that nurse practitioners and physicians provide the same level of care. So is that going to be taken into account?
Thank you for the question, Representative Burrows. So they do, and that's the reason that we're here. But initially, I proposed legislation that standards. We know that Anthem is already doing this. Others are not, but are open to the conversation. It's how to get that there, and it belongs in the insurance statute, not the Nurse Practice Act. So as a step to get this moving forward, the compromise was to use the level of licensure in the contract negotiations by these nurse practitioner-led practices to have something to point their finger to try to get a better rate and get closer to the same level of rates that the physicians have. That's the best that we're at right now, and
It was
we're
a
good.
brilliant compromise.
And it was proposed by others and agreed to by the crew. Thank you.
Representative Herbert has a question.
I wondered, excuse me. My understanding is that primary care physicians are becoming rare.
Yes.
And that the hospitals I don't know what they're doing with them. I actually happen to really like my primary care physician. So, and I'm not knocking the, what was the difference that you mentioned? If you're not a primary care, who else is doing it?
The nurse practitioners
Nurse
who are-
practitioner.
who are
And-
here. Yep.
And I'm not dissing that at
Right.
all. And in fact, the data indicates that they do a really good job. But my question is, how do we preserve the primary care physician? Because I think they're in difficulty.
So thank you for the question, Representative Hebert. The best way for me to answer that is that I mean, we're aware of the problem in New Hampshire. We're aware of the problem nationally. I'm going to point to the the State Office of Rural Health, which brings as funding from the federal government and works to do student loan payback programs to recruit, specific types of physicians into the state to help. That's just one example to help alleviate this problem, which is, really honestly at a crisis state for primary care. So there have been, and that's probably the example I can point to most quickly as a strategy to address this. So I love my primary care provider. Shout out to Debbie Glazer. She's wonderful, but I know she's rare. Okay?
Okay, thank you very much.
I have to, get shout out to my mother, my daughter, my primary care. Thank you, Representative Hunt and Committee.
Right. It's not the Oscars here. Okay, Michelle Heaton.
Hello, Michelle Heaton. I'm the Director of Life and Health at the New Hampshire Insurance Department. I guess I'll start off by answering some of the questions. The way this kind of started out was under CMS guidelines for Medicare reimbursement. They allow a step down in reimbursement rates for APRNs and PAs, and this is nationwide. And it's good to note that across the nation, the scope of practice for APRNs is different. In New Hampshire, we have a very broad scope of practice, and the APRNs can practice independently and they can prescribe. So in that respect, they are on the same level as doctors. So under the Medicare system, there is a set rate, and that is the 100% rate that the doctor would get. The CMS system allows an APRN to have a reduced amount of 85% of that rate. It is not mandatory, it is allowed. So I think this is what this bill was intended to do, is that assuming all things are level in provider reimbursement, you can't just knock them down to 85% of what you would have paid them just because they're an APRN. So that's the issue that we're trying to fix here. In this state, yes, there's workforce shortages for healthcare providers, all over the place. For that reason, that is why the market has required APRNs to be reimbursed in New Hampshire at a higher rate. And that's why I believe Anthem reimburses them on par with doctors, because they understand we need primary care providers and we're going to have to pay them more. When we're talking about provider reimbursement, it's rare that two doctors are going to make the same amount. There's a number of factors that go into their contractual negotiations between the health carrier and the provider. And those can include the geographic area they're in, the type of practice they have, how many patients under a carrier's plan go to that practice, how their expertise, how long they've been practicing, do they have enhanced certifications? All of those factors go into contractual negotiations and setting the reimbursement rates. What this bill would do is make it so, assuming all of those other factors are even, you can't reimburse APRNs or PAs or any other licensure at a lower level than at the level for a doctor. So I'm happy to take any questions. I hope that clarifies.
That help you out, Representative Spear?
Yeah, I think I got it.
Great. Thank you very much. That was perfect. Okay, what should I do next? Okay, so I'm going to call on, because I have no idea what she's going to say. So, Margaret Donovan from DMC Primary Care. You didn't check off whatever you were going to say, so.
Good morning, Mr. Chairman and members of the committee. My name is Margaret Donovan. I'm a doctorally prepared family nurse practitioner. I'm also the clinical director at DMC Primary Care. I have worked as a nurse practitioner in family practice for the past 8 years. In my role as a nurse practitioner, I provide primary care to a panel of my own patients across the lifespan in the greater Derry area. My patients view me as their primary care provider and are confident in the care that they receive. The greatest joy of this work is to see patients through the many highs and lows of life, always focusing on disease prevention and health promotion. As a nurse first, I feel uniquely able to provide patient-centered care. I'm proud to work alongside an incredible team of physicians, nurse practitioners, and physician assistants at DMC Primary Care. I value the experience and knowledge base that all of my team members bring. In all, we serve 80,000 plus patients in southern New Hampshire and have clinics across 7 communities. We have advanced practice providers that have been with our organization for over 2 decades. All of our providers do the same work. We all treat and manage acute and chronic conditions in all of our patients. Our clinic days contain the same appointment types, complexity, and responsibilities. As I say to our providers that are new to our organization, it's often hard to remember who has what credentials behind their name. Our practice hired and onboarded 12 advanced practice providers in 2023 alone, with an 100% retention rate. Our APP recruitment has fostered our organizational ability to continue to accept new patients and to keep an open access model. For the past several years, DMC Primary Care has admitted over 10,000 new patients to our practice every year. Our patients are able to be seen same day, often within hours. This keeps the cost of overall healthcare down by keeping patients from seeking unnecessary emergency care. Well outside of our offices, it is well documented that nurse practitioners are essential to enhancing patient access, particularly for rural, underserved, and vulnerable populations. Multiple studies have consistently demonstrated that advanced practice providers give high quality, cost-efficient healthcare. The state of New Hampshire has recognized this by allowing nurse practitioners to practice independently, free of physician supervision for many years. Nurse practitioners practice autonomously, assessing patients, performing, supervising, and interpreting diagnostic and laboratory tests, making diagnoses, initiating and managing treatment, coordinating care, and counseling and educating patients and their families. For all these reasons, I urge you to support that nurse practitioners be provided equal reimbursement for performing the same service as our physician colleagues. Closing the reimbursement gap is essential to ensure that all patients have access to high-quality health care. I'm confident that this will have a positive impact on the overall healthcare landscape in the Granite State. The status quo just won't do. Thank you.
Thank you. I think we're all set. Thank you very much. Chair will call on Heidi Kroll. Yep.
Good morning, Mr. Chairman, members of the committee. For the record, my name is Heidi Kroll. I work at Gallagher, Callahan, and Gartrell, and I represent AHIP, which is America's Health Insurance Plans. I'd say at this point we're neutral on the bill, as you've heard from Senator Prentice. We did oppose SB 558 as introduced, and also some earlier draft amendments to the bill. So we did oppose the payment parity mandate, where all nurse practitioners would kind of automatically be paid the same as physicians. We objected to that fact, to that for a number of reasons. One, that a payment parity mandate would be government intervention or interference into private contract negotiations between the two private entities. As you know, and as you've heard and discussed, reimbursement rates are negotiated between providers and insurers, and there's no really one formula or set reimbursement rate for a provider, regardless of what type of provider you're talking about. Furthermore, earlier versions of SB 556 really would have been unworkable because there is no single reimbursement rate for physicians. So it was kind of like what parity with what. And as you heard, it would have also been going into the nurse practitioner statutes, which just would have been problematic from a perspective of carriers need to be confident that when they are looking at the insurance statutes, that those are the laws that they need to be complying with. So with all of that said, AHIP did have a number of discussions with Senator Prentice, the bill's prime sponsor, and advocates, and ultimately offered the language that is before you today that we thought could offer a reasonable alternative path forward. So that's what I have.
Perfect. Thank you.
Thank you.
All right, so I have no opposition to the bill. I can only say that to all you I'm going to call up. You're all about 3 minutes, and I'm supposed to say, please don't repeat what someone else has already said, which might not leave you with a lot to say, but we do want to hear from you. All right, Kim Mohan. Yeah, there you go.
Good morning, and thank you for your time. I will keep my remarks quite short. I am the Executive Director of the New Hampshire Nurse Practitioner Association. I'm joined today by several of my colleagues. I wanted to point out a couple of things. There's been references this morning to primary care physicians. That is an accurate term. However, I want to be clear, when you're selecting a PCP, when you purchase your insurance and you select your PCP, you are selecting a primary care provider, which all of the commercial insurers in New Hampshire agree that a nurse practitioner is equal in being able to be that person as your physician. So Representative Herbert, you mentioned that you have a primary care physician that you really enjoy, but you're concerned about how are we going to make sure that everybody has the ability to have a PCP? Well, we do that by making sure that everybody can afford to stay in business. And part of how we do that is we make sure that they're reimbursed for the services that they provide at a rate that makes sense and is fair. I will say that New Hampshire Medicaid has recognized this. For a long time, there's been parity. Nurse practitioners and physicians are paid equally for the services that they provide by New Hampshire Medicaid. We do have data that will show, we've seen in some of the insurers' policies that they clearly state that they will pay nurse practitioners at the 85% following Medicare. So we know it's happening in New Hampshire. We also have data analysis done by the All Claims Database, which is which clearly shows we've looked at it. A group has looked at it, and they've looked at the 99214 billing code, which is a pretty general visit, and they've laid out all of the primary care physician or primary care provider primary care practices in New Hampshire. So all across the state, they've looked at physician-led, nurse practitioner-led, and combined. And then they've looked at all the commercial insurers, put them all in a column, and then they sort them. And clear as day, all of the nurse practitioner owned and led practices fall at the bottom third. So when we talk about how we make sure that we keep those PCPs, we got to make sure that they're not vulnerable just because they have a different license that gets them to be able to do the same exact service. So I'm going to leave it to my colleagues behind me. Anybody have any questions?
Okay, Nancy Wilson.
Good morning, Chairman and members of this committee. I'm Nancy Wilson, a former nurse practitioner. I was employed by Concord Family Medicine for over 10 years. I'll make this short because most of this has been covered already, but I am today testifying in support of, I'm sorry.
No, you had it on. You just need to do closer. You need to turn it back on
Okay,
and then
all right.
keep it close. Right. So you notice how close I keep mine to me.
Yeah, I
'cause,
do. All right, thank you. As I said, I'm testifying in support of SB 556, which addresses payment parity to New Hampshire nurse practitioners. We do enjoy a broad scope of practice, which has been established for years here in New Hampshire. it's really important to know that each state actually has their own scope of practice. Not ideal, but here in New Hampshire, we are actually able to practice autonomously and therefore assume the same liability risks as physician practices, same overhead. And because in New Hampshire particularly, small businesses seem to be the backbone of this state, it's important for nurse practitioners to be able to realize the benefits of opening their own practice. And I would like to support, this bill would support that. Thank you.
Great. Thank you very much. If you have written testimony, you can certainly submit it to the clerk.
You got some.
Okay, great. Peggy Abbott.
Am I the last?
No.
All right, I will talk quick. Thank you very much for inviting me to speak here. My name is Peggy Abbott. I'm a psychiatric nurse practitioner. I work in a treatment center, and I help people who deal with mental illness as well as their addictions. New Hampshire needs more psychiatric providers in the community to help these people maintain sobriety while taking care of their mental health. Many psych providers have long wait lists. I know of several psych nurse practitioners that take cash paying clients because the reimbursement rates from the insurance companies isn't sustainable to support overhead and living expenses. The ones who do take insurance have incredibly long wait lists for clients to be seen. And it's very defeating for someone to beat addiction and get mental health treatment while in recovery, but they can't have support once they're in the community. I also have a private practice and take insurance, including Medicaid. The number of inquiries for new appointments has been overwhelming, and most of the calls are from people who have Medicaid saying they've been calling around for months trying to get treatment for their mental health. I got credentialed with Medicaid because I was sad hearing the sighs from people on the other end of the phone when I had told them that I wasn't. They'd beg me to help find them somebody who could see them, stating, "Nobody takes my insurance." Medicaid is known for its lower reimbursement rate. The patients are usually the sickest, so we want to help them. With the low reimbursement rates from our commercial insurers, it's difficult, and we use that balance to make ends meet. It's clearly stated in the insurance contracts that our physician colleagues can get 15% more reimbursement than we do for the same services to similar patients. How is this fair? Patients appreciate nurse practitioners and seek the quality of treatment we provide. We are first trained as nurses and have the holistic approach that patients like and trust. We are not less than our physician colleagues. We are simply another choice. Our care should not be discounted. There's a constant growing need for psychiatric providers in New Hampshire. Dual diagnosis is rampant in our state. A quality of reimbursement for the vital services we provide would show our worth within the insurance company. The citizens of New Hampshire who pay out of pocket for treatment because the insurance reimbursement rate is so low would appreciate it, especially when they also pay for insurance coverage. Thank you.
Okay, so I just want to make sure I understand, because did you say Medicaid does pay a difference or doesn't pay a difference? Parity. I thought you just said that there was a 15 Medicaid, there was a 15% difference.
No.
Okay, all right, I
No.
misunderstood what you said.
No, it's just Medicaid reimbursement can be a little bit lower than the insurance companies.
That we know, that Medicaid is the lowest of all possible reimbursements.
So we use the commercial insurances to balance out the
Got it.
Medicaid.
Okay, great. We do have a question.
Thank you, Mr. Chairman. I'm sorry, I probably should have asked this sooner, but can you, and if not you, then maybe someone else, can answer what's the difference between a physician's assistant and a nurse practitioner and the level of training versus a physician's level of training?
Okay, that's a great question. So nurse practitioners are nurses. So we've gotten training as a nurse, whether it's probably a registered nurse with a bachelor's degree. And then we have extra training at a master's level, and we are board certified in our specialties. Physician's assistants are, they have a bachelor's degree, and then they get 2 years more of training in the medical environment. And did you ask about physicians? Yeah.
Yeah, I mean, physicians get 7 to 8 years of college training and experience residency and. so,
Correct.
okay.
Yeah.
So follow up.
Further question, may inquire.
Thank you. So is this bill just for nurse practitioners? It's for physician's assistants as well?
Just for nurse practitioners.
Okay, thank you.
You're welcome.
Not the way I read it. Unless it's in, yeah, no, like it says, a healthcare carrier should not establish payment and reimbursement based solely on the provider's licensure. So it would be everything. Anything and everything.
Could be 5% for everything.
Okay?
Okay.
Thank
you very
you.
much.
See, the things we learn in public hearings. Isn't it good why we have these hearings? Okay. Faith Kreft.
They're getting 85% of physicians, MDs.
What's that? Oh, wrong. It's 8 versus 6. Okay. All right. Ryan, do I have the right one? Okay, Ryan Aquilina.
Good morning. It's Aquilina.
Aquilina.
Nice try. All right. So I understand that this bill is geared toward primary care, but it also affects me as a licensed clinical mental health counselor. So first, I wanted to thank you for even considering this bill because reimbursement parity among licensed clinical mental health counselors and licensed social workers has been a fight that I've been having since I opened my practice in 2021. The reimbursement practices for behavioral health are discriminatory at just about every insurance company. And I'll say that I worked for a psychological practice before I hung my own shingle, and I took a 30% cut from not working under a psychologist and practicing independently. So I run Bodie Counseling Services, which is a 27 clinician practice, and it has a statewide reach and is currently serving over 1,900 active clients. Pay equity for mental health counselors has been a forefront issue since we opened, and not a day has gone by that either I or my administrative staff haven't fought with insurance companies to get paid fairly for the work we're doing. I also had to recently make the difficult decision to not take Medicare at my practice, and it was because of this issue, the inequitable reimbursement practices. Because social workers and licensed clinical mental health counselors do the same work, but they're reimbursed differently. And I'm going to give you sort of the Cliff's Notes version of my written testimony because there's a pretty specific story about an issue that I have with New Hampshire Medicaid. But my primary question actually that I'm coming to you with is, would this bill also cover Medicaid?
No.
No. Okay. I would ask that you consider that it cover Medicaid if it's possible, because private practice licensed clinical mental health counselors make 80% of what they do in community mental health centers. And so it's because of, so if you look at the fee schedule, which is public information, licensed clinical mental health counselors, the rate is 80% of the same service in the same billing code. And so we just had a pretty big rate increase for Medicaid back in January, which I'm very, very thankful for. So thank you for your work on that, whatever your role in that was. But the margin is still unacceptable. So before the rate increase, we were paid 67% of what community mental health centers were paid. And if community mental health centers didn't have such long waiting lists and those clients were not coming through our doors, I probably wouldn't be making such hay out of this issue. But there's at least one community mental health center that doesn't even have clinicians and isn't keeping a waiting list. And so they come to us. And so we're serving higher and higher acuity clients for much lower wages. And this is across the board. Medicaid just happens to be the most glaring issue, but it's happening across the board with all insurance companies. So
I appreciate your time. I gave you my written testimony, but I'm going to give you the Cliff's Note. Like, I just wanted to make it brief.
No. Great. Thank you very much.
All right.
One card left, Sabrina Dunlap from Antrim. And now I know what you wrote there. I think you meant to say neutral, but you forgot the T.
Sorry about that.
So
Very messy handwriting. Well, thank you anyway. Yes, neutral. Sabrina Dunlap, Director of Government Relations for Anthem, and appreciate Senator Prentice and the other stakeholders looping us all in early, and this was a collaborative process. I just wanted to point out one thing to the earlier issue that came up. Hoping that we can change provider to specify that it is limited to APRNs. I would defer to the nurse practitioners as to what exactly the correct phrase is. I don't know if it's NP, I think it's APRN, but just to clarify, because otherwise that becomes a relatively broad amendment to the existing contracting standards statute.
I think we just discussed that with the person who testified before. So wondering whether it's going to cover a mental health provider.
Well, I think APRN is probably broad enough to cover medical and mental health, but this provider would apply conceivably to every provider. So hoping to limit it to just nurse practitioners.
Okay, we'll make note of that.
I did just chat with Susan Paschel. I think they're okay with that because that was our collective understanding.
Okay.
All right. Thank you.
All right. Having no more cards, I will close the public hearings. Okay. No, it's not.
558, another insurance. These are all pretty sticky.
All right. Last but not least. This will be our last Senate bill
Of the session.
of this session. We'll have heard everything, and then we'll spend the next 2 weeks.
Well, I think you'll enjoy this hearing so
Processing.
much that
I think there's a
go
little
out
bit
with
of
a
deja
bang.
vu here, right? Okay. So open up the public hearing on Senate Bill 558, and you don't look like Representative. Okay. Did you fill out a pink card?
I did.
Okay,
I
so
sent
it
up
might
with
be in this
Michelle.
file. Here. But go ahead,
Okay.
fire away.
Good morning, Mr. Chairman and members of the House Commerce and Consumer Affairs Committee. For the record, I am Senator Rebecca Perkins Quokka from Senate District 21, the city of Portsmouth, and the towns of Durham, Lee, Madbury, Newcastle, Newfields, Newington, and Newmarket. I'm here today to introduce SB 558, an act relative to insurance coverage for infertility treatments, protection from discrimination during IVF treatments, parental leave, and adoption. We all want to see New Hampshire thrive. Our job as policymakers is to set up a system where we can step aside and let our residents pursue their lives and empower them to achieve their dreams. What it means to build a family in New Hampshire will always evolve, and today I'm here to address pieces of that. As a representative of my generation and also our sorely needed workforce, I believe additional pieces around family building are necessary to maintain our competitiveness and attract and retain the workforce we need for the state we all love to continue to grow and thrive for generations. Workers, as patients, are looking and comparing their lives in various places and the protections available there around building a family, and it is increasingly a core piece of where people choose to live and build their lives. In families I talk to every day, the families that make up this workforce and the core of our economy, these concerns are at the forefront of their lives, especially women who contribute so much to our state, but frequently both parents experience much anxiety about whether they can get pregnant, balance their jobs, talk to their employer, leave for a doctor's appointment, and demonstrate their commitment to their work, all while trying to accomplish the goal of building a family. Housing and other rising costs simply require that many times both parents be at work. These are people we want to support. They are people we say we value, but we need to demonstrate that value through some simple pieces. This bill asks to expand diagnostic insurance coverage for same-sex couples and expands our pregnancy discrimination statute to encompass the real situations our constituents deal with. These are highly personal matters. One might argue that in today's employment market, employees have a lot of negotiating power to address these issues with their employers. And yet we see that even today, even in that employment market, these issues are not being addressed. Our residents are still hard workers, they're still professionals. Negotiating parental benefits and accommodations can feel like talking to your employer about time away from your job, when in fact you are steadfastly committed to it. Giving our residents these simple pieces will be small in continuing to build a modern economy for our state. That modern economy recognizes that workers need different support than we needed 30 or 40 years ago. If this feels novel, just talk to any employer out there. They will tell you the workforce and healthcare standards have changed and that our job is to support the economy and these workers so that our small businesses can find what they need to continue to function. The version of the bill as amended by the Senate represents countless hours of work by very many invested stakeholders, including practitioners, attorneys, the New Hampshire Insurance Department, insurance carriers, and legislators. The Senate has slimmed down the bill to its core essential functions, ensuring coverage for the diagnostic pieces required for same-sex couples and protecting employees from discrimination for simple leave. I hope you have all seen the updated fiscal note as amended, which is attached to the bill. And it states a very reasonable cost for these small pieces that can bring very large economic benefits to our state. With that, I'm happy to take any questions. Thank you very much, Mr. Chairman.
Any questions to committee members? Seeing none, guess it's a pretty straightforward bill.
All right. Thank you,
Okay.
Chairman. I would be grateful if you would call Catherine Tucker next, just because she.
Okay, normally we call
Smart
the
person.
insurance department, but if you want me to,
Oh, okay. You were the chair, but just wanted to put that forward.
you want her next.
Thank you.
Okay. All right. Since the insurance department is busy working on an issue that I just asked him to do, we'll call up Catherine Tucker. And I hope you're not going to take 10 minutes. Thank you. Turn, you have to put the mic on. There you go.
I'm not.
Red is good.
It's good. Okay. Thank you. My name is Catherine Tucker. I live in Laconia, and I am also an attorney that practices out of Loudon. And folks, I picked up a copy of the bill off the table, and it had the wrong fiscal note attached. So I just want to make sure everybody's working off the right fiscal note because there is, tremendous difference. The one that is correct is amended on 4/18. So this bill has two pieces. The first piece is the insurance piece, and what this piece does is it provides coverage for people in New Hampshire in large group plans to have intrauterine insemination procedures done. IUI is a procedure where sperm is placed into the uterus with the goal that the sperm makes its way to where it needs to be to the egg and everything happens so forth. This has a much higher success rate than putting the sperm in the vagina because the sperm is much closer to where it eventually needs to go. So this procedure is a very low-tech, small procedure that is a tiny piece out of what the cost study looked at last year. As you remember, we talked about a cost study last year that was extremely broad. This is one tiny, low-tech piece of that. This procedure, because it requires a uterus, is only going to help those people who have a uterus. So specifically, the groups that are going to be helped are female couples and single women who have not only a uterus, but who have a fallopian tube and an ovary in order to make this work. Intrauterine insemination, IUI, is the first line medical treatment for these two groups of people. Bottom line is, these people need help. They need medical help to get pregnant, and they need donor sperm, and the donor sperm has to find its way to the egg. So the piece of getting donor sperm is not covered. We are not asking the insurers to pay for any of that. A lot of that can include non-medical costs. That is not, that nothing is changing with that. That's going to be out-of-pocket self-pay all the time. What we're asking for payment for is the placement of that sperm into somebody's uterus. And that is a low-tech medical procedure. It doesn't involve IVF. It doesn't involve surrogacy. None of those expensive things, egg retrievals, any of that stuff is not involved. It's a very low-tech, simple procedure. And it's a procedure that is recognized by the American Society for Reproductive Medicine as medically necessary for these folks. And I'll pass around something in a moment. But what happened in 2023 is that the American Society for Reproductive Medicine changed its medical guidelines and said, you know what, infertility does include those folks that need medical intervention, including but not limited to the use of donor gametes in order to achieve a successful pregnancy, either as an individual or a partner. So we now are in a position where the leading medical authority considers this treatment medically necessary for female couples and single women. And the reason that we're saying 6 cycles is because that's the medically defined limit. That's what doctors are going to recommend, 6 cycles of intrauterine insemination. If you're not pregnant at the end of 6, we need to rethink things and see if there's a problem going on here. Like I said, it's very low tech, it's inexpensive, it's something that can be done by a doctor, a nurse practitioner, a physician's assistant. It's not something that people are doing at home, though. And I just wanted to address a misconception that I had heard. I had heard that this bill might help male couples too, because it gives them the option to have an insemination done on their surrogate. And I just want to say that to inseminate your surrogate, that's traditional surrogacy. We don't like that. We don't favor that at all, not in our law or our practice. It's not illegal, but it's essentially a co-parenting arrangement with your surrogate. So there's no doctor or lawyer that's ever going to recommend that as a good thing. So this is a bill that helps specifically single women and female couples. And right now, these are folks that are paying out of pocket for that medical treatment. So not only do they have all these expenses from getting the sperm that they have to pay out of pocket, they also have to pay for this intrauterine insemination procedure out of pocket, when their colleagues who need that same procedure, their straight partnered colleagues, don't have to pay for that procedure. So it makes sense to have this particular piece covered. Now, the second part of the bill talks about employment leave. And I just want to mention that when a person is going through fertility treatments, particularly the female partner, there's going to be a whole lot of appointments. Most of these appointments are routine, quick, in and out. For example, an intrauterine insemination, you go to the doctor, 15 minutes, you go home, you go back to work. There's occasionally a longer appointment, such as for an embryo transfer or if a person needs to have surgery. But primarily, these appointments are quick in and out, and doctors will schedule them during the lunch hour or during early morning hours to help people not have to miss work.
So how much does it cost?
I understand that it's 5 cents.
No,
per
no,
mi-
that's not the number I'm interested in. How much are these people who are doing it now out of pocket? How much are they spending?
Thousands of dollars. And I've got some folks here that are going to testify.
Thousands of
Yes.
dollars?
Yes.
Then how can it only be 144 for the whole state?
Because we are not, there's no coverage for the part of getting the sperm. The only coverage will be for placing the sperm into the uterus.
So the thousands of dollars includes getting the sperm.
Yes.
So what this covers, how much does this cost?
A few $100s.
A few $100s.
I believe the insurance department has those numbers.
They don't have it. That's why I went over there. She has it now. So that's what I went over to ask. Okay. So it's that the getting the sperm can be very expensive.
Mm-hmm.
That's still, the person still has to pay for that.
Yes.
You won't be back for that bill next year.
No.
We got YouTube now.
Not next year.
Oh, wow. Excuse me. You'll never be back for that?
For the stuff that has to do with the sperm bank and the compensation to the donor, the travel costs for the donor, the legal costs for the donor, no, I'm not going to ask for that in the future.
Okay. Okay. So, Representative Ammon has a question.
Thank you, Mr. Chair. Thank you for your testimony and your explanation. I just want to make sure I understand the two parts of the bill. So the first part is the intrauterine insemination, and that's a very specific procedure that the insurance would have to cover.
Yes.
The second part has to do with leave, and the reasons for the leave are much broader, right? It's not just for that procedure.
Yes.
It could also be for any other infertility treatment.
Yes, that's
Is that
correct.
right? And just to follow up.
For the question, may inquire.
So reading the fiscal note, it talks about it could potentially add a burden on municipalities and counties because they have employment contracts that are already existing, and they may not have very many employees, so they couldn't afford to lose one for a couple of weeks. Is that your understanding that this could potentially be a mandate on municipalities and their workforce?
Yes, but a couple of weeks, that would be a highly unusual situation. That would be a significant surgery, just like any other surgery. If we're talking about the treatment, the standard treatments, those are not going to be 2-week-long procedures. It's going to be a 1-day office visit. You're back to work the very next day.
Yeah, so why do we have all this stuff in here then? Why is that here? If it's just an office visit, why? When I was reading, I was thinking it was lifting from our statute, in that which is that an employer can't fire someone who's out on pregnancy leave.
Yes.
Okay, so is that what this is trying to recreate here?
Yes.
Because that wouldn't matter, because that statute doesn't ask how you got pregnant.
It clarify that we're not including just that when you're actually pregnant part, but the trying to get pregnant.
Right, but you just said it's an office visit,
Yes.
1-day office visit.
But so you go to work in the morning, you go to your office visit at lunch, and then you go back to work would be a quick office visit. A
Right.
longer office visit is you take the whole day off from work.
Again,
Am
I
I
don't
not
understand-
being clear?
If that's just 1 day, why do we have all this in here? Why do we need to put all that in here?
Well, we want to make sure that people are protected when they take that 1 day off or take that
That
off.
they could get fired for that 1 day?
We want to make sure that doesn't happen.
Okay. All right. We do have a question. Representative Spear.
The actual procedure of inserting the sperm, which is what we're covering, which is what we're talking about, but usually these procedures, there's talks about medication, there's talks about doctors monitoring blood and all this other kind of stuff. We're not talking about adding any of that?
I think that would be a case-by-case decision made by the physician as to whether that person needs medication. Now, in terms of monitoring, yes, you do have to put the sperm into the uterus at the right point in the woman's cycle. So there's a lot of inexpensive monitoring supplies, things that can be done at home that people would just buy over the counter and monitor themselves at home. And then go into the office when their test kits are indicating they need to be inseminated.
Aren't you discriminating against gay men on this bill?
Yes, but this is a step in the right direction, and I think it's a very important step. Female couples are in this unique position of they can get pregnant, but they got to spend a whole lot of money out of pocket in order to make that happen. If we can protect this segment of individuals, I think that is a
Well,
giant step in the right
I
direction.
know David Crosby's not alive anymore, but I've heard of someone just gets a guy and helps them out with that procedure. That doesn't cost him anything.
I'm not following what you're saying.
I'm sorry, I don't know, Mr. Crosby.
You don't get it. That's okay. Okay. Thank you very much for your testimony. You have a question for her? Do you take one more question?
I'm sorry?
Would
Yes.
you take another
of course.
question? Okay. Representative McHugh.
Thank you, Mr. Chairman. On the far right side of this chart, why should the try at home be 12 months and not 6 months?
So when you're trying at home, what you're doing is you're placing sperm into the vagina, whether you're doing it through sexual activity or whether you're using a syringe and putting the sperm into the vagina. It goes into the vagina right by the cervix. And then the sperm has to make its way all the way through the cervix and into the uterus and up the fallopian tubes. So there's a lot more that the sperm has got to do on its own, and therefore the success rates are a lot lower. We're talking probably 5% success rate per month versus 15 to 30 if you place the sperm in the uterus.
Swim, swim, swim. Okay.
But shouldn't it be 6 months, the same as 6 rounds? As far as how long the waiting period is for
Sure.
both columns,
Sure.
both situations, both living or life situations?
So if you're putting
Just so there's parity?
yep. So if you put the sperm into the vagina,
No, I got all that
the-
part. I got all that part. I
Okay.
don't think any of us need that lesson. I hope not.
the
But
recommended,
both columns, right? Both types of living situations here. 6 rounds, assuming that's 1 round a month, versus 6 months before that insurance coverage kicks in. Shouldn't it both time periods be 6 months? That's all I'm asking.
that's intentionally set at different time frames, and the
Why?
reason because when the lower success rate with the intravaginal or intracervical insemination means that you try more times before you say this isn't working. Versus if you put the sperm into the uterus, you only have to try 6 times before you can assess whether this is not working. So there's medically defined different standards, and we're looking at what the doctors say. If the procedure you're doing is an IUI, 6 months is the medically appropriate time to try that before we say, hey, wait a second here, there might be something else wrong that we need to examine.
So if we wanted to give parity on the timeline, we could either change that to 6 months, or we could make this 3 rounds or 6 months or 6 rounds or 12 months, whichever is greater or something like that. If we wanted to establish parity in timing based on the medical evidence, if you wanted to do
This
that.
bill will be in a subcommittee and
Right,
we'll
great,
discuss
thanks.
it.
Just one comment, if I could. There is a 12-month ICI on the left-hand side.
That's current statute. I'm talking about what the bill's proposing.
Yeah.
Okay. sorry.
Okay. Thank you very much. Chair will call on Michelle Heaton from the New Hampshire Insurance Department.
Hello, Michelle Heaton. I'm the Director of Life and Health with the New Hampshire Insurance Department. Just to level set, we are neutral on this bill. We are not taking a position. It is a policy decision for the policymakers to make what benefits you want to mandate. To give a little background, we do already have a fertility mandate for the large group market, and that covers all medically necessary fertility treatment. What this new mandate would do is outside of what is medically necessary. And it would require that insurers cover up to 6 rounds of IUI in a plan year. And to get to your questions, Representative Hunt, last year in our claims data, we observed 499 distinct claims for this specific procedure. The median price for this procedure was $128. We assumed in the calculations of our fiscal note, which we had the whole worksheet filled out and OLS condensed it down, so a lot of that got cut out. But we assumed an upper limit of an increase in claims of 1,125 claims. So that would be a little bit more than double the number of claims right now. To give a little bit more background, there was a bill about expanding access to fertility services last session that we did a mandate study on over the summer. That was a much broader mandate study, and some of our assumptions are based on some of the stuff in that report, but this is a very much more narrow mandate. So it's essentially requiring that insurers cover 6 rounds of the IUI procedure. It does not mandate coverage of any medications or testing that may be necessary or appropriate for this procedure. And I'm happy to answer any questions.
Thank you very much.
Oh, yep.
Oh, do we have questions? All right, Representative Walls first, and then Representative Spear.
Thank you, Mr. Chairman. I'm just looking at the verbiage in this bill. Does the insurance industry see a difference between IVF and IUI? Because I see that's both are stated, like an act, it says during IVF treatments. Should it be amended to say fertility treatments?
Oh, are you looking at the description above?
Yeah, the
IVF?
description, right.
I think that's, so this bill has been amended. We have been working on this for several months. So I think that may have been the initial intent of the bill. What the language is that was landed on was just IUI. So I'm not a doctor, but I know a little bit based on this bill. And IUI is a specific procedure
yeah.
that was just being described to
Right,
us.
I understand
IVF
that.
is
But
in
I'm
vitro
just asking
fertilization. Yeah.
insurance coverage wise. I'm not asking for the
Okay, so
I already know the details.
currently under insurance coverage, if you have a diagnosis of infertility, all of the different array of services that may be necessary are covered.
Okay.
What this does is it makes this specific service available without having to have that diagnosis of infertility.
Thank you.
Thank you very much. Oh, there's Representative Spear. Yes, sorry.
We just were handed a definition of infertility, and you had made the comment that it doesn't have a medical necessity, but based on the definition, we were just handed it is a medical necessity. So, did you
I
hand
believe
this out?
I did not. I
Okay.
believe that is a policy statement from a specific group. I would not consider that to be the accepted medical necessity, and that is not in line with the way our statutes
Do
define
we
medical
have a
necessity.
definition someplace in?
Yes, we do.
Can
And
we see it? Can you tell
Oh
us where
boy,
it
it's
is?
yeah. No, in the old days we used to be fighting over the language for every session.
Where do we
So,
find it?
it's in 420J3, the definition.
Sorry, would you go a little slower?
420J. That's the magic number. That's the magic RSA.
41J?
420 dash
RSA
J
420.
:3 is the definition section for managed care.
Thank you.
And I don't know exactly the Roman numeral, but
That'll
there is
keep-
medical necessity.
That'll keep you
in there.
busy all weekend reading that chapter. But when that list where I send out all the mandates, they're all 420Js.
Oh, okay.
Okay.
This specific one is its own chapter, though, specific to fertility
Right, the
treatment.
fertility is a separate, but 420J is where you want to stop shopping. Okay, thank you very much. Heidi Kroll.
Good afternoon. Good afternoon, Mr. Chairman and members of the committee. For the record, my name is Heidi Kroll. I work at Gallagher, Callahan, and Gartrell, and I'm here today representing AHIP, America's Health Insurance Plans. Before I forget to mention it, I will also say that there is the medically necessary language is also reflected, and this was a deliberate decision that we made when we were working with the stakeholders a number of years ago when we put the fertility statute on the books, as a brand new statute. So it is also in 417-G :1 under the definition sections. It's Roman 6 under the definitions. You'll find the same definition of medically necessary. We put that there as well. So first, I just wanted to say that we truly appreciate the time and the willingness of the prime sponsor and the advocates and the insurance department and other legislators, Senate staff. Everyone put a lot of time and effort into this bill. So it's been a very good stakeholder process, lots of meetings and phone calls and many, many drafts. So the communication around this bill was very good, and we really appreciate that. The issues around this bill are complicated, as you may recall from looking at similar legislation last year, including how to balance compliance with medical necessity law, our anti-discrimination laws, and then, of course, the cost impacts of this mandate or really any new mandate. We do appreciate that the bill has been substantially narrowed from its as introduced version. We do think it's a better structure compared to the prior drafts that the stakeholders were considering, and it's certainly more straightforward and certainly easier to understand what the new mandate would be. As you might imagine, we do still remain concerned, about language that talks about coverage, regardless of whether or not the individual has a diagnosis of infertility. So this is really getting at the heart of medical necessity, as you know, is a cornerstone of managed care. It ensures that people are getting appropriate quality care and that we're watching out for the costs that are being borne by the premium payers and by the patients themselves. So this language, obviously circumvents medical necessity, and that's just always going to be a concern for the carriers. And it's concerning really because it opens the door to potential future mandates that also might seek an exemption from medical necessity. And of course, that could really be a slippery slope and a costly one as well. As you know, the cost of new mandates are always a concern for us. I am aware that the bill's fiscal note estimates the cost at 5 cents per member per month. So that is certainly lower than some of the estimates that were associated with prior drafts. So that reduction is very good to see. However, obviously this is a brand new mandate, both here in New Hampshire and really across the country. As the prior speaker was mentioning, there was a change at by this association back in late fall, October, November. So, it's really just been in the last 6 months or so that a handful of states are moving in this direction. And so, part of what carriers are grappling with is that there's not really a good handle anywhere. We can't really look to other states to get a good handle on what the actual cost will be or how they might grow over time. And of course, this is one of probably a number of mandates that will pass or might pass this session. So we're always cognizant of the fact that these things do add up. And of course, costs go up over time. So with that, I'd be happy to try to answer any questions. I did want to mention, and I'm sorry that this did not come to my attention earlier when this bill was in the Senate, but the effective date is 60 days after passage. I don't have any position on the second part of the bill around the employment piece, so I don't know what makes sense for an effective date there, but at least for the mandate, the insurance mandate portion of the bill, if you are inclined to move forward this, we would respectfully request an effective date of January 1st of 2025. So my apologies for not picking that up when this bill was in the Senate.
Okay. Any questions from the committee members? Seeing none. Oh, we do have a question, Representative Prisali.
Thank you. A quick question. So what insurance segment would this pertain to? If
Yes.
we look at the pie chart.
Sure. Yes. Thank you for the question. So this, our current law around fertility treatments, and this one would be consistent with it, only targets the employer fully insured market. So my recollection is that that number is somewhere around 21% of the market. So it doesn't target the individual market fully insured, and it doesn't target the self-funded market or Medicaid or Medicare or any of those other forms of coverage. So it's exclusively employer-sponsored, fully insured market.
Yeah, hence the seemingly low number. Okay.
Thank you.
Thank you. All right. I have 4 more cards here. Everybody's in support. So all I can say is please don't repeat what the last person said. And we'll start with Faith Kraft.
Hello, my name is Faith Kraft, and I'm here testifying in support of SB 558. So I am in a same-sex relationship. My wife and I just got married 6 months ago, and so we are starting the journey of parenthood. And so the comparison of parenthood for a same-sex couple, for women versus heterosexual couple, there's a lot more hoops to jump through, a lot more costs. So right now, because I am in a place where I'm unemployed, I could begin this journey of wanting to become a parent and know that I can take this time off, maybe incur the costs that come with buying the sperm, storing, shipping, and then IUI, or I could get a new job and then hope that I can have that paid parental leave to, one, become a parent, but even leading up to it, taking all this time off needed to have IUI for the journey of parenthood. As Catherine mentioned, IUI, it's recommended for 6 cycles. With each cycle of IUI, there is a lot of appointments that come with that because there's the pre-testing, there's genetic testing to make sure the sperm that you're using isn't going to have some genetic issue, making sure you're not a recessive carrier for something. There's blood tests. There's a lot of appointments leading up to the point of IUI, which fine if that's not covered by insurance, but then IUI, if you're doing 6 rounds of it, that's maybe 6 months, if not longer. And so leading up to that, you need to purchase 3 to 5 vials of sperm from a sperm bank. And my wife and I, we've been looking at the costs. That can be upwards of $10,000 for the sperm, for the shipping, for the storage, just to get it to the doctor's office. So there are grants available to cover that right now, but a lot of them state that you need to be someone with a prior medical condition, and it's not deemed medically necessary for a same-sex couple. So my wife and I would be the one that would carry, and we are in the preconception part of getting ready for parenthood, where we would meet with our OBGYN, and she has to do all this testing to make sure that I am in a good place to potentially start the process to become pregnant. In a heterosexual couple, they don't have to do all this pre-testing or pay out of pocket for sperm or anything. And so we are looking at incurring a very large price to become a parent. And it's not a guarantee that I would get pregnant off of the first vial of sperm. My wife and I joined this queer conception group where we've heard stories of same-sex couples, it's taking them years to become pregnant. So there's no guarantee that off the first vial I would become pregnant. If it's years of a process, that's a lot of money. And also insuring with an employer, if I am trying to become pregnant and it takes years to become pregnant, there's no guarantee currently that the employer would allow me to keep going to these appointments to become a parent. So that's, again, another hurdle to becoming a parent, and it's not fair. There's another restriction, I guess, to becoming a parent. And so for me, I have ultimately wanted to become a mom, and I see all of my heterosexual friends who are able to, they have sex, great, they become pregnant. But the difference between IUI and IVF, big difference. Doctors need to do this procedure because they can track to make sure that the sperm is being properly placed in the uterus. If you're doing this at home, you're not properly storing the sperm, it could go to waste. You're wasting a ton of money. And so it's really important that you have the medical necessity from a doctor that states that you are able to have these costs covered by insurance, but then also have them tracking the procedures that are happening. So again, it is very expensive and a lengthy process. And so for me to become a mom, this is very personal to me. And I would like to know that I don't have to spend $10,000 plus whatever the cost of all these medical appointments are going to be. So again, this is a medical necessity for me as a same-sex couple. I know it's not for heterosexual couples, but being able to know that the insurance will cover this and that we don't have to fight with insurance carriers before we even get to these appointments. We want to know that we can go to the appointment, it's going to be covered, and that we can hopefully become a parent within the first couple of rounds instead of waiting 12 months and then potentially having to do IVF, which then even that's not covered by insurance. So I'm happy to answer any questions. I hope that covered it.
Representative Spear.
Thank you. I missed something that you said because I got something a little confused. So there's a lot of stuff that goes on before you ever get into the office to actually have the IUI procedure.
Mhm.
And you said that that could cost as much as $10,000.
Yes. So,
That, but that's not the question.
oh, sorry. Yep.
And that there are grants available to help with that.
Yes.
Did I understand it correctly that says those grants are limited if you don't have insurance for the IUI part of it? Or
Tho-
did I misunderstand something?
No, those grants are limited to people that are already deemed like infertile or you have already a prior existing medical condition. It's not available for same-sex couples that are just trying to become pregnant.
So you have to pay the $10,000
Yes.
equivalent
Right.
already.
Right. And that's not even the issue, like whatever we have to pay that. But then on top of already paying $10,000, all those medical appointments will add up really quickly.
Sure.
Yes.
Okay, thank you very much. Chair will call on Devin Quinn.
Hi, Chairman and members of the committee. My name is Devin Quinn. I'm the Director of Policy for the New Hampshire Women's Foundation. I actually wanted to read a letter from an OBGYN who couldn't be here today, if you'll allow that. This is from Dr. Janet Perkins Howland. Dear esteemed legislators, I'm writing to urge your support for the inclusion of medical coverage for intrauterine insemination for lesbian couples within our state's healthcare policies. I also write as an OBGYN who has spent her entire career in the great state of New Hampshire. IUI is a vital assisted reproductive technology that enables many couples to conceive and start families. However, despite its proven effectiveness and importance in addressing infertility, access to IUI remains limited for lesbian couples. This lack of access poses financial burdens when seeking to build families. Once lesbian couples decide to start a family, IUI is physiologically necessary as a first step. Every individual, regardless of sexual orientation, should have access to the medically necessary treatments and services they need to start a family. Furthermore, endorsing the coverage of IUI for lesbian couples aligns with our state's values of fairness, compassion, and support for families. I urge your consideration of this important issue and to support legislative measures that would clarify the medical necessity of IUI for lesbian couples. Your endorsement of this initiative would have a profound and positive impact on the lives of many individuals and families in our state. Thank you for your attention to this matter. Dr. Janet Perkins Howland.
Great, thank you very much.
If I may, there was one question you asked about the coverage issue or the municipal impact. And I just wanted to, I guess, sitting here, you saying, do we really need to make sure that employers would let someone go to a fertility treatment appointment? And, you know, that's actually why we have it already in the books for prenatal appointments. And you might think the same thing. Wouldn't everyone allow people to attend prenatal appointments? But unfortunately, we do have to have that in statute for the very, small number of employers that may not understand the importance of that. And so it mimicking that prenatal appointments is also really important too. And that's unpaid time. And as you heard, it's quick appointments, but maybe few appointments, maybe many appointments, but they're quick. And so we just want to make sure, especially if an employer doesn't understand fertility treatments, that they understand that they do need to make sure their employers can attend those appointments, if that clarifies.
Thank you. Any other questions? Seeing none, thank you very much for your testimony. Chair will call on Brianna Henkel. From New Futures. Okay. Good afternoon.
Good afternoon. My name is Brianna Hinkle, and I am the Legal Policy Fellow at New Futures. My testimony focuses on the second part of the bill, which is the workplace protection, especially for postpartum care. Currently, the US is in a maternal mortality crisis with a lot of maternal deaths, mostly happening around postpartum care. So it's important to have those workplace protections so people can go to doctor's appointments and stay healthy without using all of their paid time off and needing care. And I can answer any questions if there's any.
What? Well, because I know we have in our statute that we want to protect pregnant women. It doesn't say how you got pregnant. There's no issue there.
Yeah.
So I'm surprised you're talking about postpartum, because that's after the baby's been born, and that we give we give you a woman right to stay home, and that we mandate the employer can't fire you. It's got to take you back when you're done.
Yeah.
you know.
Postpartum deaths can happen up to a year after the pregnancy, and so that's more broader. So
Oh, so you're adding to the length of time?
no, just for postpartum care in general.
Okay. Great. Thank you. Any other questions from the committee members? Seeing none, got one card left. Lindsay and Natalie Harrington. Yeah, you have to turn it on. It has to be red. I guess we should have been green.
Good afternoon, and thank you, Mr. Chairman. We are here in support of SB 558. My name is Lindsay Harrington. This is my wife, Natalie. We reside in Concord. A few months before we got married in 2020, we began the truly romantic task of deciding if it made sense to be on the same insurance policy. Working for larger nonprofits, we both had reasonably affordable premiums. The main difference was that Natalie had a significantly higher deductible. In 2020, I had been working for my current employer for over 5 years and knew my insurance premiums, coverage, and deductibles were some of the best in the state. It's important to note that my current organization has generous parental leave and a comprehensive, integrated equity, diversity, inclusion, and belonging program. Surely my benefits would make the most sense for us. I did my due diligence and met with my benefits department at work. I shared the details about Natalie's policy, and the benefits director and I agreed my organization's policy likely made the most sense for us. I then got that pit in my stomach and remembered to ask, I just want to confirm, you're saying we, my future wife and I, we are fully insured for fertility treatment? She nodded and said emphatically, yes, Lindsay, we are fully insured. In February 2021, we began our family planning journey, a journey that we quickly learned would be very costly for us. After some initial tests, Natalie was ready to start IUI cycles. When we talked to our financial counselor at Boston IVF, she told us our insurance does not, in fact, cover IUI treatment in cases where infertility has not been diagnosed. And we would need to complete 12 cycles unsuccessfully before infertility coverage would kick in. The expected out-of-pocket cost would be somewhere between $12,000 and $25,000, depending on our particular course of treatment.
Confused between what we had originally been told by our insurance and what we were being told by the fertility clinic, we contacted our close friends who happened to work with Lindsay. They had the same insurance plan and received treatment at the same fertility clinic with the same provider. We asked our friends what her and her husband had paid. They were very confused by our question, but shared that after 18 months of treatment, they'd paid maybe $200 in copays. Their treatment was covered by insurance, while we would have to bear the burden of all costs associated with our treatments. In March of that year, we contacted our reproductive rights attorney, Catherine Tucker. Catherine helped us request the right paperwork from the insurance company and encouraged us to appeal this decision. Through that appeal, we were provided with some additional relief. The number of out-of-pocket rounds was reduced to 6. Given that we are 2 women in our 30s, we made the decision to move forward with treatment. At that time, each round of IUI cost us out of pocket $1,100. In addition to the cost of the IUI, we also had to cover other fees associated with our treatment, including sperm, medication, and blood work. We spent $2,700 purchasing 3 vials of sperm, one of which would be stored for future use, adding an additional cost of $3,100 for storage. Not including the storage fees, we spent a total of $5,122 before having a successful pregnancy.
We have spent the past 2 years discussing when we'd be ready to start trying for a second child. The primary deciding factor on timing was determining when we could balance the financial burden of fertility treatment, a factor most couples don't have to consider. With each cycle, we must examine other areas of our life and determine the priority, balancing regular monthly expenses, extracurriculars for our son, or necessary home improvement projects. 3 months ago, we started a new round of IUI treatments, and last week we had our 3rd cycle of treatments in hopes of bringing a second child into our family. The cost of IUI treatment has increased to $1,650. So far, we have spent almost $633 on medication, $441 on blood work and testing, and $2,415 on 2 additional vials of sperm, bringing us to a current running total of $9,190 for our second round of treatments.
Our average total cost per cycle of IUI increased 45% between 2021 and 2024, from $2,050 to $2,957. If we end up needing to pay for 6 cycles of IUI out of pocket this year, we will spend over $18,000 before our insurance kicks in. Waiting to hear if a treatment was successful is an extremely stressful period. For us, this stress is compounded as we are forced to look back at our finances to determine when we can plan for a 4th round. We know trying again right away won't be an option for us, as we have spent almost $3,000 in the past 3 months for each treatment. We will probably need to take a few months off to save for additional cycles. Our question for the committee is a simple one. What is a family worth in New Hampshire? For 5 cycles of IUI treatment to build a family so far, we have spent $16,512.25. If we need to complete the additional full 6 cycles for IUI this round, we will spend over $26,000 building a family. Is it worth it? Absolutely. Is it fair and equitable? Absolutely not. The fact is, it costs more to be a same-sex parent in New Hampshire than it does to be a straight parent. In New Hampshire currently leaves it up to insurers and companies to define what equitable treatment actually looks like.
We fully support the Modern Economy Act and the benefits it would provide to families across New Hampshire. We appreciate the committee's consideration of such an impactful legislative opportunity. Thank you.
Great. Any questions? Representative Spear.
The costs that you indicate, or costs that are similar to the costs that I looked up online to find out, this bill, this current bill, is covering a very small part of that. Do you, is this going to make any difference to you? I mean, it's such a small part of the whole cost of IUI, the whole package, getting the sperm and everything else.
It would make a significant difference. The sperm alone costs so much money that being able to offset any of that cost with any of the treatment being covered would allow us to immediately jump into another cycle. Because we would be able to, personally, we could afford the sperm right now. We could not afford the additional cost of the IUI on top of that.
Thank you very much. Having no more cards, we will close the public hearing on Senate Bill 558. And we will do the subcommittee next Tuesday. Health bills will do next Tuesday.